The committee of the whole will resume in order. Sergeant Arms, could you please re-escort the panel back to join us for the second half of the proceedings? Thank you, General, for joining us. For the record, the representative of the Mayor's Council was unable to attend for the second half. If a member of the Mayor's Council is necessary, we can go ahead and put the request in. But absent that, we'll go ahead and proceed. We left off prior to our recess with Acting Speaker Terlahi having the floor to present her questions to the panel. You have the floor, Madam Speaker.
Thank you very much, Mr. Chairman. Thank you all for being here and providing testimony this morning. I guess I wanted to start with the Attorney General's office. So we had received earlier testimony from your office in November and regarding the bill, the prior version of this bill, where you had talked about the violation of separation of powers. And so this morning on review of this substitute bill, I understood you to say that this substitute bill still does not cure the defect of separation of powers. Is that correct?
Yes, that's our position.
Thank you. And also that the executive branch has not determined the liability under these circumstances, and it should be the executive branch that determines if, in fact, the government is liable, and whether the license is valid, and the absence of any government claim being filed or any litigation being filed during the 17 years raise questions also whether it might be too late for them to file a claim or seek payment through litigation or other means. And I think you had also said that from what's before us, it may be impossible for the legislature also to determine whether the government is in fact liable under these circumstances.
Yes, I agree with all those statements.
Mr. Roker, can you please speak into the microphone very clearly?
Yes, I agree with all those statements.
Thank you. I am concerned about that because, and I guess it all goes back to if anyone in the panel, if I want to know if anyone in the panel is aware if there's been any procurement for cocoa recycling services that we haven't talked about yet. I mean, that is the basis of this claim. Was there ever any anything issued by GSA or DPW, a procurement? Like, is there a contract pursuant to any solicitation?
And do any members of the panel wish to provide a response? Mr. Reck, you recognize.
I'm not aware of that.
All right, so then the only contract that I can see then that where liability is being claimed is this license agreement with the Chamorro Land Trust Commission. So I guess I'd like to go back to that then. And so the Chamorro Land Trust Commission, pursuant to its license agreement in 2001, that was signed by the director back then, Joe Borja, and Cocoa Recycling only, not even the AG's office or anyone else signed that contract, that license. So that license agreement was for, to lease out Chamorro Land Trust property to this company, and the rental amount was determined to be $6,600 some a year. A month, sorry. So $6,600 a month. And so originally, Cocoa Recycling should be paying Chamorro Land Trust $6,600 a month for use of the property. But Chamorro Land Trust wanted to clean this property up, so they wanted to give kind of an in-kind exchange in this license, it looks like, so they allowed them credit. But if I understand your position correctly this morning, the terms of the license on its face are limited to the $6,600 a month for 5 years, which could have been extended for 3 more terms of 5 years, so up to 21 years, for a total amount of $1.6 million, or approximate. And although, so that's kind of the lease amount that we've been talking about pursuant to the license. And so you are willing, Chamorro Land Trust is willing to give that credit to cocoa recycling. Do you need legislative approval for that?
I don't believe we do, because the contract that was endorsed by COTC and cocoa recycling expressed that. Although you're correct, it didn't go through the other channels of approval that these things normally would have gone through.
All right. And so we seem to be here in the legislature because Chamorro Land Trust has, I think, rightfully determined that it's beyond their authority to approve any amount beyond the 1.6 million. That any speculation as to, 7.5 million, or even if you want to say, even if Chamorro Land Trust wants to say they picked up $7.5 million worth of, waste, that your agreement, your license, really only limited your liability to $1.6 million. And the Chamorro Land Trust has never, since 2001, agreed to this proposed new license that would have increased your liability beyond the 1.6 million. Isn't that correct? That you've been asked several times. Since 2003, I think this new license proposal has been put in front of the Chamorro Land Trust Commission, and they've just not signed that since it's been proposed. So we're still operating under the original license?
Correct.
So I think in the absence of this, any amendment to the original license agreement, they tried by an amended license to expand the liability of the Chamorro Land Trust, and I'm glad the Chamorro Land Trust did not agree to that. I'm glad that the Chamorro Land Trust has submitted testimony saying they do not believe they should be liable for anything above this amount, and I'm glad that AGs will look at the liability of that amount. So I think we're here today, this bill, because it's not something that's been procured through normal procurement process. It's not something that's been covered by the original license agreement, or even, I think, within the Chamorro Land Trust mandate to clear up typhoon debris across the island of Guam, that you're going to incur $7.5 million liability for that. So we're here today because this is an exceptional set of circumstances that even if we accept the premise that the company cleaned up the island after a typhoon, they did it without a contract in place. They did it without any kind of procurement. They did it without any type of license agreement or any kind of agreement to bind the government of Guam in this huge $7.5 million liability. And so we are here today, and obviously they haven't gone to court to settle this. So we're here at the legislature, I think, is a very almost extreme measure, and that is, because, some people recognize there's work that has been done, so we feel bad. Oh, they did the work, we should pay for it, but I can't help thinking it's something that, it's like me going out, and saying, I'm gonna go clean up Jotnya. And I'm going to do that on my own, and I'm going to clean it up. I don't have a contract. Nobody's promised me. Maybe they promised me verbally. Maybe the mayor said, yes, do that, and I'm going to give you something. But 17 years later, I go back to him and I say, hey, you owe me. I just think they would laugh at me, and I'm not saying this is a laughable matter because I know it's very serious. But I am saying that we're talking about sophisticated companies with sophisticated lawyers, and I respect Attorney Hareki very much. I'm probably one of the best lawyers on Guam. And But I think we just have to recognize here as senators that we're doing something unusual, very unusual, recognizing a liability, and that's what the bill seems to be intending to do, is to recommending to the CLTC to amend. They can't even use the original license, but they would recommend an amendment to the license that would then incur a liability for the CLTC for these amounts. And the bill would incur a liability for, the government of Guam's payment of these amounts. I'm also concerned with, in addition to whether there really is a liability on behalf of the government and whether, this is prudent of us to pay something that we are not, technically liable for, especially without the involvement of the AG and their, defense of the government of Guam in that type of a claim. I'm also concerned with the source of the funds that we are going to pay for this work that was done is our recycling revolving fund. And this recycling revolving fund has been a source of contention for many years. And we all know that its purpose, and I think it was stated earlier, I'd just like to remind the public that might be listening. So the recycling revolving fund is, we pay this $25 for every vehicle that we register. We pay for motorcycles registration, we pay for heavy equipment registration. All of that goes to this recycling revolving fund with the purpose Recycling Industry Economic Stimulus Program. This is where EPA pays companies to remove or to take care of recyclables. So these companies are not taking care of our plastic bottles and our aluminum cans necessarily without this stimulus. Or EPA is trying to increase the type of recyclables that can be picked up by these companies, because I think it's been in the news recently that where we used to send these products are no longer accepting these things, and we are looking for other ways to deal with recyclables or to create some type of use for them here, because we are unable to ship them. And so we are in I think a huge need, and I want to recognize that that is a very huge task that's been put on EPA right now, is to find a way to get rid of waste when our avenues of getting rid of that really have been very limited. So this fund was supposed to help them to, give to these companies some incentive to help us in this regard. It's also supposed to fund an employee at the EPA, like the director said, that's solely dedicated to administering and implementing all of these recycling and recycling programs. It's supposed to give at least $300,000 to the Guam Zero
Madam
Waste
Speaker,
Plan.
I don't mean to interrupt. Are you going to pose a question to the panel?
Yes, there
or?
is.
Okay.
The Guam Zero Waste Plan, and that's a plan, and again, that there was one in 2013. I think it's been updated, has it not? And they've been working very hard on this. And I agree with you, Mr. Leon Guerrero, that Guam EPA should be very, very proud. I think in the last few years, the work it's showing to me that you've come up with updated plans, you've come up your updated rules and regulations, and these rules and regulations, the use of the recycling revolving fund has not been up to EPA because of EPA's has not yet passed its rules and regulations. So the legislature has been taking the recycling revolving fund and doing what it wants to with it for prior years. And now that EPA is on the eve, literally, of getting that hearing on their recycling revolving fund rules and, their rules and regulations, yes. That hearing is set for tomorrow. Coincidentally, that, we are having this today. Tomorrow, they are laying out for the people of Guam their intended uses of the recycling revolving fund, which takes care of all of these priorities that were set by the legislature. First priority, junk vehicles, tires, batteries, waste oil, white goods and appliances. Second priority, paper, cardboard, plastic, and glass. Third priority, other recyclable materials. And the programs that have been set out in the rules and regs they're huge. They talk about the Guam beverage container recycling, which has been, some of these
Madam
things
Speaker,
have been
I
put
believe
on.
they'll be covering that at the public hearing tomorrow.
No,
what the rules and regs will cover.
But this is
If you can-
important, Mr.
If you
Chair.
can get us to the question.
Yes. They lay out a plan for use of these funds. And today we are asking that they divert use of those funds for something else. And so I want to confirm. So the administrator of EPA, Mr. Longarero, you said earlier that these rules and regulations actually make a plan for use of in excess of the amount available in the fund. Is that correct?
Per annual year or fiscal year, correct.
And I think that's evidence of a great need for these funds to take care of, these very noble programs that have been put on hold for very long, years. And I guess I wanted to ask you, if you had to cut, now what are we proposing here? $500,000 a year?
I'm sorry, Senator.
Wait, the bill proposes to cut from the fund and give to this purpose to pay cocoa recycling. I just want to get the correct amount. $590,000? Yes, approximately. So what would you cut from your listed intended purposes in these for the recycling revolving
Madam
funds?
Speaker, I believe that question was proffered earlier by Senator Lee. The response from the administrator was that he's unable to answer that because the decision is not his to make, and so that question has been asked and answered.
Mr. Chair.
I'm trying to keep us moving along so we're not. So do you have a follow-up question to that initial
Well, I'd like
question?
to ask the administrator. What would you cut here? Do you have a priority listing of what?
So Senator, what we would do is once the rules and regs are promulgated and gives us the opportunity to choose between those multiple decisions, we would look at the status of the island of Guam, and we would
Say that again.
the status of the island of Guam. Where are we at in recycling, and what would be the most beneficial use of this money based on our rules and regs? And so, with that, Guam EPA would come up with a recommendation. We would run it by the board, and then we would act on it if the money is available.
Well, I'm looking at a letter from August 2017 from Guam EPA to Speaker Benjamin Cruz, because there was a proposal at that time to take revenue from the recycling revolving fund and divert part of it towards the Mayor's Council of Guam, part of it towards the University of Guam for the sole purpose of funding the operations of its Island Sustainability Outreach and Action Program, and part of it to the Guam Zero Waste Plan. And in that letter, Guam EPA details the cost of each of these programs that's being proposed in your rules and regulations. And I guess I just wanted, are these costs still valid? Like, for example, the Guam Beverage Container Act cost $400,000, or that's what you were proposing.
That is correct.
And so there are some that are less, but if I could read it very quickly. Zero Waste Plan, $300,000. Mayor's Council Island-wide Cleanup, $400,000. Guam Beverage Container, $400,000. Solid Waste Green Waste Plan, $300,000. Disaster Debris Management, Temporary Sites, $500,000. That's the one you were talking about earlier. Community-based programs, $100,000. The stimulus program, $500,000.
Yeah, Senator. So yeah, those were approximate figures that we put together. Again, once the rules and regs are promulgate it, that's when we can actually go ahead and start taking a look at what the actual cost would be. But those are approximated, and we'd still stand by it, if not increase it, because just the natural inflation of
All right,
2013.
is it still the EPA, Guam EPA's position that diversion of the recycling revolving fund from these purposes does not support the legislative intent of the RRF, which is the removal of recyclables from Guam? The end result is that many recyclables, especially those with low market value, will accumulate throughout the island or be illegally disposed. This agency sees no direct value in the diversion of these funds, specifically towards operational purposes, to the Mayor's Council or the university, or versus the actual removal of recyclables. It remains our hope that these funds will be used towards the removal of junk vehicles, white goods, tires as part of the operations. Guam's environment has a direct causal relationship with the island's economic and social welfare. Since its inception, records will show that this agency receives little to no funds from the general fund. As you may be aware, in light of the current realignment of federal priorities, Guam EPA is expected to receive a reduction of 7 to 35% in grants. With that said, the operations of this agency will be impacted, and we will have no other recourse but to either reduce our service to the public or seek funding from the general fund. Concerning this agency's mandated obligations, Guam EPA does not support the diversion. It stands to reason that programs such as, in this case, it was the UOG's Island Sustainability Outreach and Action Program, should create its own sustainable funding mechanism or seek another source that actually mirrors its purpose. Should this bill remain unchanged, then this agency requests that all its legal obligations and liabilities for providing stimulus funding to recycling companies be removed. In addition, the waste characterization of many of the island's dump sites contains significant quantities of recyclable materials. Therefore, the agency also requests that it be released from its mandate to take enforcement action against recycling facilities who must accumulate these materials beyond their capacity because of the changing market values, and individuals or entities who are unable to take their recyclables to a permitted facility due to a lack of funding. This is your testimony back then objecting to removal by the legislature of the recycling revolving fund from these purposes that are outlined in your rules and regulations that are set for hearing tomorrow. Is that correct? So do you agree that removal of $500,000 or $600,000 from these purposes is going to have these same types of effect that you described?
Madam Speaker, I'm going to have to interrupt you there. The administrator answered earlier in a line of questioning from Senator Rodriguez that the expenses in this bill are consistent with
Mr. Chair, could I don't want
Mr. Leon to be at the risk of perjuring himself by mistakenly answering your question,
Mr.
which is in
Chair.
regards to a different letter.
I'm sure he can handle it.
From Bill 350. He was asked earlier if the measures in Bill 350 were consistent with the mission of EPA,
Mr. Chair,
and he said yes.
I would ask that we just be allowed to ask them the questions. They be allowed to answer without your directing them how to answer.
These gentlemen are under oath, Madam Speaker, and I don't want the question to be misinterpreted in a way where his answer now to you is going to be inconsistent to his answer to Senator Rodriguez, and then he would have perjured his testimony. So it was testified earlier by Mr. Leon Guerrero that the payment of a prior obligation as suggested in this act is consistent with the mission of EPA. The letter you're referencing is diverting funds.
Mr. Chair, could I please have the director? He can make those clarifications, I'm sure.
I just want to make sure, because I'm chairing this, I want to make sure that I'm not going to be allowing for the panel either to walk into to potential perjury unintentionally. And so we've had a question asked earlier that was in nature with respect to the bill. Your question is actually not with respect to the bill, but with respect to a letter that was transmitted
It's with
previously.
respect to the use of the recycling revolving funds over which the administrator of the Guam EPA is currently charged and tasked with administering.
And he did
and he has a
answer-
hearing set for tomorrow, and I'm asking him the impact of removal. And if I could just have his answer. Mr. Chair, when we set out our rules this morning, you know, the process was that we are going to be able to ask our questions to this panel, and we're going to ask them as quickly as we can so they can get back to their regular work, and we can presume with our debate on the bill. So we can debate this later, but I'd just like to get the questions answered, please.
The question that you're asking was already answered.
Are you denying my question? Can we just have it answered then by the administrator while he's here?
I believe the question was already answered, Madam
Then
Speaker.
I'll restate it, Mr. Chair.
Okay. Sure.
Mr. Administrator, when we removed the $500,000 that you believed would be available under the recycling revolving fund for your rules and regs, you said the board would determine the priorities and they would determine which of these programs, and I read out the costs of all of these programs, would be cut, right? Or which one would you would prioritize? And I'm asking you if your sentiments in 2017 when we were diverting money from the recycling revolving fund and the impact it would have on your mission at EPA, whether this bill has similar impacts on your mission at EPA.
Thank you, Senator. I think I kind of addressed that with Senator Espadon's question. If they take a fourth away of any budget, it of course will have an impact to the decisions you make. It will reduce the type of work that you can do by a fourth, and that's math. That's simple math. Yes. And again, I'll just restate it one more time. It'll reduce the amount of opportunities that we have to implement some of the things that we have in our proposed draft regulations.
And when your board at a recent meeting, did they discuss this bill? Wasn't that the sentiment of the board, that they wanted to make sure that the legislature is aware that that type of impact would be had on EPA's abilities?
That is correct. Last month's, or actually this month's board meeting, they had discussed, last month's board meeting, excuse me, they had discussed the proposal on this bill, and they just indicated that it should be noted that the legislature, that this, again, through the simple math of removing money from the fund, does not enable us to expend it on our draft rules and regs.
There was testimony at a confirmation hearing of the chairperson of your board, where one of the other senators asked him about use of this recycling revolving fund. And he said, I would not be in favor of directing money outside of the rules and regs of the RRF that's being put in place. I think that money, if it's owed, needs to be paid, but from my standpoint, that should be gotten from the general fund or for some other appropriation, and not take the money that's earmarked for sustainability, zero waste, recycling, and education. I think all those things are important, and we need to stay the course on that and not delay the implementation of those programs in order to pay this other debt, which is not really connected to the RRF in any way, shape, or form that I can see. Are you familiar with the BBMR's fiscal note or comments on this bill?
No, I'm not, Senator.
All right, well, part of it, they talk about how the recycling revolving fund was sent to the mayor's, or it's sent to EPA for FY 2018, and Guam EPA was supposed to make an MOU with the mayors for use of this recycling revolving fund. And so then it says, as of September 30, 2018, the total RRF appropriation for the GEPA Mayor's Council of Guam has an expenditure balance of $177,000 and an encumbrance balance of $2 million some. Can you explain that? Why the expenditure balance is so low and the encumbrance, is the encumbrance still encumbered? I mean, is that going to be spent?
I'm not quite sure what numbers you're referencing, Senator. I'm not too sure exactly right now when you're talking about that.
But as far as you remember, the MOU with the mayors was for the whole 2.8, 2.9 million?
Correct.
And did you expect them to use it all?
I was I was hoping that they would use it all. I know that they didn't use it all. And I think that's why this body had allowed them to continue to use it for this fiscal cycle.
Yeah, so it says that it's encumbered, so it looks like that was set aside for use, and we didn't take it and appropriate it again. And there was another appropriation for FY19. And this one goes to Guam EPA. And so on passage of your rules and regulations, you would be able to use those funds?
That is my understanding, yes, ma'am.
All right, without an additional appropriation?
That is correct.
All right. All right, when this, it looks to me, well, I'm not sure then who on the panel would be able to answer, but it looks to me like when this fiscal note was prepared by BBMR, they had not incorporated the plans for the rules and regs when they made these findings. I'll stop there for now, round one, Mr. Chairman. Thank you.
Thank you, Madam Speaker. We have Senator Morrison, Senator Castro, and Senator Ms. Davis on round one that have not had an opportunity. Any of you senators wish to be recognized for round one? Senator Davis.
Thank you, Mr. Chairman. After reviewing the discussion earlier from this morning, just a couple of follow-up questions. This is to the representatives from the AG, maybe Mr. Orcutt. In 2001, was it a requirement at the time that contractual obligations be routed through the Attorney General prior to signing?
I couldn't give you a legal opinion right now. I don't know.
But is that the standard practice today? Contracts, bonds?
That would be more of a solicitor's question than a litigation question. I'm not sure. And I don't know if litigation or solicitors knows.
Today, if the governor is signing the contract or the agreement, it must be vetted and approved by the Attorney General.
And so there is precedent then for individual line agencies to enter into contractual agreements, purchase orders that are binding through their own executive authority. Would that be an assertion?
I'm sorry, can you repeat the question?
So for example, I'm a line agency. Am I able to enter into contracts within my agency with vendors without the signature of the governor? So not every single contractual obligation is routed through the governor. Is that correct?
I think that there's some of the purchases that are made through GSA are through purchase orders, which do not normally go through the governor's office. But if the agency itself is contracting with a third-party vendor or such, and that's gone through a procurement, under normal circumstances, that would go through the Attorney General and the governor.
Thank you. Mr. Borja, do all contracts and do all license agreements, or correction, leases, as we refer to them now, are all leases signed or reviewed by the Attorney General prior to its signing?
Well, as a normal order, we would. We have not issued any commercial leases after we've already passed the rules and regulations. So none of that, I can't say we have done it already, but all these license agreements are older agreements. But if it was today and it had something to do with money and it required the governor's signature, yes, it would go through the vetting process to the Attorney General. Just as a note, when we have done just memorandums of agreement or memorandums of understanding between different agencies, if there's funds to be exchanged, we go through the whole process and we allow the Attorney General to determine whether or not it requires their signature or the governor's signature, and if it doesn't, then we pass on that. But we go through the full clearance now.
Does this 2001 license agreement, does this predate your rules and regulations regarding commercial licenses?
Yes, it does.
To direct it towards the representatives from the Attorney General, What would be criteria? So if you were to review the license agreement, what would you be looking for as to whether or not to determine its validity?
Well, I'm not sure I can really give a thorough answer. I haven't even ever, frankly, read the licensing agreement at this point. But you'd have to look at what the law was at the time, and then you'd have to look at the provisions of the licensing agreement and decide whether it's consistent or not.
I see. And right now, it's not your assertion as to whether it is or is not valid. Is that correct?
That's correct. I mean, I think the issue I wanted to raise here today is that we really don't know because we have not been involved in the process, and that this is a process that should occur within the executive branch, not a legislative function.
And that's your only position in opposition, is that language that might violate separation of powers, not as to the validity of the license agreement, correct?
Well, I think we've said that we believe this violates the separation of powers, and I think the rationale behind that is the one that I've been speaking about, that a decision like this really belongs in the executive branch. I mean, there's a reason we have separation of powers, and there's a reason why the executive branch is given the powers that it has, and the legislature is given the powers that they have.
And so there's been a lot of discussion on the Government Claims Act, and I think in both provisions in the Government Claims Act, under Section 6310 and Section 6210, both of them require for any settlements that are above the Government Claims Act balance, which we know $7 million is definitely above what we have available, it has to come before legislative approval. And so just as a natural course of procedure, I think it's already outlined in statute that everything has to come before this body. And it also outlines that any settlements or anything that claims that need to be made are to be paid through the agency's budget to be appropriated or budgeted in their budget by the legislature. And so, I mean, I'm like hearing with your regards to this should exclusively be part of the executive branch, but I think the claims against the government are very specific in statute that it belongs to the legislature.
I don't quite agree with what you've just stated. There's a whole series of statutes that are set up so that if there's inadequate funding, you have to go to the legislature and get...
Correct. It's in this act.
And that's because the legislature, of course, has the power of the purse. They're
Correct.
the ones that make the appropriations. In other situations where the money's available, like say if you have the money in the Government Claims Act, obviously you don't have to come to the legislature and get approval for that.
Correct. I said that, so I think we were in agreement on that point. I was just stating for the public record, Mr. Chairman, that there is not enough money in the account. The account can't cover the $7 million plus that's being discussed today. I just wanted to clarify on that point.
If we can also just, I don't think Mr. Orcutt answered the question about whether or not the AG's office was objecting to any of the language and the license.
Yeah, and I think they clarified that, right? You're not objecting to you're not objecting or supporting the language of the license, right? That's not what we're discussing.
Right, yeah, that's our point. We have not made an evaluation of that.
And so I guess my follow-on question to that, assuming that the license is valid, just, the AGs they didn't review it, right? They can't say either way. And it's already been determined that this was prior to the rules and regulations requiring the Attorney General. And if I could just add, the intent, as I researched, for having that in is to protect the government from getting into contracts that could potentially be damaging or place us in a liable position, right? So we want the AG's opinion and review prior to getting into contracts. But as being discussed, this predates those rules, and we can't go back in time. We woulda, coulda, shoulda had the AG look at it, but we didn't. Would it be your assertion that can you find any reason, and just speculating, why this contract wouldn't have been valid after signing? I mean, because I think it's already been determined, and in just a recent ruling by the Superior Court, that the contract clause in terms of the government's position or assuming liability is binding upon signing of those contracts. And that's just been determined recently in another case involving government liability, whether or not the contract was valid. The contract was signed, and that's been upheld. And so do you think this is potentially any different now that the contract's been entered into?
Senator, I think because they've already answered that they have not reviewed the license, I don't think they can comment as to whether or not there are components in it that would not be valid.
So regardless of whether there are components in that are valid or not, would you agree that, or would you be able to comment as to whether or not the commission at the time in entering into this agreement entered into a contract, a contractual agreement?
I can't really comment on it. I mean, that's basically the evaluation I think that needs to be done by our office.
And so I think if I could ask Mr. Attorney Harecki, at the time, if you could maybe speculate, you know your client better than I do. I guess I don't really know your client. Did he, at the time, was your client acting in good faith under this license agreement?
Most definitely. You know, the way this came up wasn't if my client was out there kind of trying to find some work for the government or saying, oh, could I do this or could you pay me for that? It was the CLTC after PACA that I think had assistance from FEMA too, that was looking for a way to clean up about 50,000 tons of waste at the Dededo transfer area. And they came to Mr. Bello. They asked him if he would enter into a license agreement. They also asked him, even before it was signed, whether he would start cleaning up the Dededo transfer area. And he agreed to do that. So Mr. Bello was responding to specific requests for his services, that is COCU services, by the CLTC. I think he was acting in absolute good faith. There was some emergency aspect to this too, because the solid waste had been, it wasn't just typhoon related, by the way. It was even 40 years before PACA that the waste, the tires, green waste, solid waste, had been placed at the Dededo transfer area. So, as I earlier indicated too, I think FEMA and DRC, a company that the government had contracted to clean up, were also working with the CLTC. So this was all part of a coordinated plan that was not my client's doing, but he was asked specifically to participate and to clean up that area, and that's exactly what COCU Recycling did. It cleaned it up. So he was absolutely acting in good faith.
Mr. Harecki, just to re-emphasize, though, there was a question by Speaker Terlahi asking if you had any documentation to that effect, asking if you had any documentation to that effect of what you just attested to. Is there, you informed us that there was no actual procurement for those services. Is there documentation validating that the request that you're saying is your response to Senator Stevis?
I believe that's the license agreement. Other than the license agreement, right. I don't have specific documentation.
So we have, other than the attestation from your party, we have no documentation that FEMA actually asked them to do this, or we have no documentation that the government actually asked them to undertake these projects?
Oh, I believe we have something in that vein, letters.
I believe that's what Speaker Tarahi was asking for, and your response was that all we have is the license agreement.
No, there's court.
But then Senator Stevis is asking you specific questions with respect to what precipitated the action of the party, and you're giving a response, but I'm following up. What is that, a documentation, or is that just an attestation as their attorney?
Oh, no. A couple of things. First of all, there is some correspondence in the file. I'd have to go back talking about the services that were being performed. We have the letter from the CLTC Director Elliott in 2006 indicating that the services were substantially performed. But in the license agreement itself, that's what I was mentioning earlier. There's the express statement that, the amount of credit for removal of metallic waste shall be at a rate of $20 per
Please speak into the microphone.
Oh, sorry. The amount of credit for removal of metallic waste shall be at a rate of $20 per cubic yard. It talks about work being performed on lot 10-12215, that's the Dededo transfer station, and separation of non-metallic debris, development of cell sites for fire breaks, and other improvements that was what the work was performed. That was the work that was performed. And then it goes on to say the amount of credit is $20 per cubic yard. As licensee has been providing cleanup services. So that's already a statement that he was already doing work on the project, and that's lot 10-12215. CLTC shall accept as credit all metallic waste removed from the lot to date, which has been determined and agreed to be in excess of 25,000 metric tons. So here's the CLTC coming to my client and saying, oh yes, we've determined, we already know that you removed 25,000 metric tons from the Dededo site, and we're recognizing that in the agreement. And we're saying the value of that is $7.5 million. And I did ask my client today, how did you know that? How did they know how much work had been done? He told me that CLTC, in conjunction with DRC, FEMA, had actually gone to the Dededo waste site and they measured how much was there. At the beginning, they had measured it as about 50,000 metric tons. And later on, when they made this determination, it had been measured. Now, we don't have records of that measurement, but my client tells me that the government had hired someone, we believe it was DRC, to go to the Dededo site to measure the amount that was removed already, and then the CTLC represented to my client that he had already removed 25,000 tons. That's a representation by an entity of this government that the work was done. And that normally, that should even stop and prevent the government from coming back and saying, oh, he didn't really remove 25,000 tons, because he relied on this. Mr. Bello relied on this. And then, of course, as I indicated, 2006, Director Elliott came back. We have that letter. We provided that to the legislature. You have substantially completed the work on the Dededo transfer station, which really meant that almost 50,000 tons had been removed. So, you know, that's the documentation. But I believe this statement, it's almost a stopple against a government entity from denying that the work was done. That is the verification. That's the substantiation.
Okay, but so in line with Senator Esteves' question, that agreement, however, was not reviewed by the Attorney General at the time, because that was not standard practice.
It wasn't standard procedures. That's what I was trying to determine. And it was going to lead into my follow-up with correction. Attorney Harecki, do you believe that this license agreement is legally binding? Would you consider this a contractual obligation?
It's a contract. Every contract has to have consideration, which means each side gets a value. My client removed at least 25,000 and probably more likely close to 50,000 metric tons. The CLTC contracted for that service. He performed the service. The people of Guam got the benefit of a cleaned up area there, the Dededo transfer area, which could then be used for purposes. There was definitely consideration flowing from promisor, promisee, all the elements of a contract that you would normally respect were present. And my client, as I said, he wasn't looking for the work. They solicited him. I think the government was in something of an emergency situation to get this taken care of. My client, Koku, stepped up to bat, and they are the ones that requested the contract. So yes, I think all the elements of a contract are there.
And thank you. Mr. Borja, in your professional experience, having done numerous leases, been a part of at least facilitating numerous leases and license agreement, would you consider this license agreement as legally binding as a contract?
I treated it as such.
Okay. And those are all the questions I have, Mr. Chairman. And again, I reviewed what was being discussed this morning, and I know there's a lot of discussion either way, and for me, I'm, keeping an open mind, I try to, coming from the private sector and hearing numerous horror stories about how businesses get, the best way to say this, get the very worst of the government of Guam. It's historic on this island, local businesses. And I'm simple, right? If the government enters into a good contract and the business acts in good faith, then we have a responsibility to uphold that. And I think that's been a consistent position of this body on numerous occasions, that businesses that act in good faith, that where the government messed up, and I'm not saying this license agreement was bad either way. I think what I'm trying to say is it was done. The work was done, the contract was done. Whether it would have been better if the AG came in, would have corrected some language, it's done, right? It's nothing we can do about that. And I think based on the professional assessments from both parties, I think then when this contract was entered into, and up to now, even with the new administrator, that I think there's still an agreement that this is binding. Furthermore, in reviewing the Small Government Claims Act, that already highlights that even if a claim was brought, it would still have to come before this body to be the authorizing entity or organization that appropriates the money. So either way, it's going to come home. And we're going to have to deal with this in making this right, whether now or then. And I think further information provided by the Attorney General, even prior to coming to the Committee of the Whole, they didn't even bother to review or even look. So, like their input is not really valid on the license agreement because they never even reviewed it prior to coming here today. And so it's of my individual opinion that I believe this license agreement is binding for the government. And while I respect and understand that we don't want to amend and say for certain that we're incurring this liability, I think, at least based on what has already been done and looking at the record, I think the government had already placed this liability on ourselves. And so I'd like to reserve for round two to ask any more questions. But that's just the information I was trying to ascertain, I think for the benefit of the body, is to clarify on a couple of those points.
Thank you, Senator Esteves. Just a reminder, what we'll do is after we've dismissed the panel and we're going to entertain any possible amendments, the floor will be open for more elaboration, as was provided by Senator Esteves, for example. Any of the other senators that have not had a round one wish to have an initial round? If not, we'll go ahead and conclude round one and commence of round two. Again, we will afford the author of the bill opening remarks and questions on round two. We will also afford him closing remarks and questions. And in between that time, all senators will be afforded another round of questions of the panel. Senator Rodriguez.
Thank you very much, Mr. Chair, and thank you again to the panel. Before I ask my question, I must say that I'm again disappointed with the Attorney General's office. When the Attorney General's office came for the public hearing, it came in and said that we shouldn't even be here. This is a separation of power. This is an executive function. And I must remind everybody once again, the panel and my colleagues were here because the executive branch, an agency of the executive branch, came to us and said that we need your action in order to resolve this situation. The other reason why I'm very disappointed is that knowing you're coming to Committee of the Whole and not reviewing the license agreement is very concerning for me. And so for anyone to even say that we're not for sure, we're not for certain that there is a government liability here, I think is misguided. We have government entities, the Chamorro Land Trust Commission, EPA is on record as well as saying the Mayor's Council is on record, government entities that have said that this is a liability of the government of Guam. And so for anyone else to say that there's a question of whether we're not sure if there's a liability here, it's very concerning. A question was asked as to where is the validation, and I know that Mr. Arecki had reiterated where that validation is. But I must say it again for the record, that on this license agreement that was signed by a government representative, the director of the Chamorro Land Trust Commission, Mr. Joe Borja, in, I believe it was in 1993. It was after the initial license agreement was authorized by the commission and signed by Ron Tehan at that time, the late Ron Tehan. This document that was signed by a government entity validated, as Mr. Jarecki has read into the record earlier, that the government, that the Chamorro Land Trust Commission had determined that 25,000 metric tons of waste have been disposed and cleaned up. And a sentence after that hasn't been read into the record on that agreement is that, in addition, any further and future cleanup work on lot 10-12215 Deredo or CLTC properties shall be credited towards rental payments at the $20 per cubic yard rate. And so there is that, again, that direction from a government entity that says whatever other work you do in that property, we're going to compensate you for it. And so I don't know how else, Mr. Chairman, we can put on record and present that this is a liability of the government. And so and I'm asking my colleagues and everyone else to look at the facts before us. If there is an issue of where we are looking to get the source of funding for this, that's an issue of this body. Later on, when the panel's excused, could debate it and could make those determinations. I'm hearing that there may, as from what I'm getting, there may be a concern that we are committing ourselves for 10 years. Hey, I'm sure Coco and Mr. Bello will be happy if we say we'll come up with a $7.5 million tomorrow. I think we got to commend and recognize Coco and Mr. Bello for them accepting that this proposal, that we are going to spread this payment out over a 10-year period without interest. And so, let's please recognize those actions that are taking place here. Mr. Chairman, I don't have any other questions for the second round, but I just wanted to ensure that I put those on record because some of these items were very disturbing as it came about in the first round. Thank you.
Thank you, Senator Rodriguez. And do any of my colleagues have any other questions for this second round of inquiries before the panel? We have Senator Nelson, Acting Speaker Terlahi, and you yield for now? Okay, Senator Nelson.
Thank you, Mr. Chair. This is for the Director, Walter Leon Guerrero. Let me just find this. On December 13, 2018, we received a letter from the Guam Environmental Protection Agency, and it reads, Hafa-Adai Senators, on November 1st, the agency spoke in support of Bill 350-34 with the understanding that every reasonable avenue to satisfy the debt between Cocoa Recycling and the Chamorro Land Trust has been fully exhausted, and with the understanding that no provisions of local government law are compromised. And that's in bold letters. No provisions of local government's law are compromised. We understand that 350-34 may have some discussion and movement in today's session. The agency wishes to remind the legislature that the Attorney General's office referenced this bill as inorganic during the November 1st public hearing. Additionally, the Guam EPA Board of Directors has mandated and motioned that the agency raise awareness on this bill's potential impacts on the initiatives in our proposed rules and regulations for the Recycling Revolving Fund, which your team at EPA has worked so hard throughout the years to solidify. Initiatives such as the Recycling Industry Economic Stimulus Program, Mayor's Council of Guam Environmental Cleanup Program, Beverage Container Recycling, green waste and disaster debris management, and our overall efforts to combat illegal dumping may see some form of impact upon implementation. To this end, we implore the legislature to ensure that this bill properly addresses any legal concerns from the AG. I'm going to read this again. To this end, we implore the legislature to ensure that this bill properly address any legal concerns from the AG and vote in the best interest for the sustainability of recycling on Guam. And that was from the acting deputy director. Then the very next day, Mr. Leon Guerrero, you wrote us a letter, and the reference is retraction of December 13, 2018 correspondence regarding Bill 350-34. And this is what you wrote. Hoffaday Senators, this letter serves as clarification on the agency's position on Bill 350-34. I am rescinding yesterday's correspondence, and I kindly ask that you disregard my acting deputy administrator's letter that all of you received yesterday. And then it goes to explain that you were out of the office, you weren't feeling well. When our Guam EPA Board Chairman Bob Perrin instructed Acting Deputy Director to carry out a request made by our board in a board meeting held on November 15, 2018. The meeting minutes are attached, and the request has been highlighted on the last page for your convenience. For the record, Mr. Perrin and the Board of Directors made a request to the agency during this meeting to impress upon the legislature's stance of the board regarding implications and ramifications of this bill this bill may have on the agency's planned initiatives in the proposed rules and regulations for the Recycling Revolving Fund. The Deputy Director's letter should have only simply stated the board's request. With this, I am withdrawing the correspondence as a corrective measure as to comply with the board, and I ask that you consider this letter in its place. And so we have the minutes that you attached, and you highlighted the area of interest, which was the last sentence in new businesses under Bill number 350-34, which states, the chairman recommended and then requested the administrator to impress upon the legislators the effect the proposed measure would have on the agency's plan with the RRF and other programs that are seeking to implement. And so I went back I didn't really see the deputy director's letter. It kind of got lost in the sauce, but then I saw yours. So then I went looking in my files for this letter that you were referencing. And I'm looking at it, and I'm really thinking, I was asking myself, what was so damaging about the letter that the deputy director wrote that you had to rescind when he was the acting, while you were out, rescind this letter? And I really couldn't see anything damaging about it. All I saw was that in the third paragraph, additionally, and I'll read it again, what the deputy director wrote. Additionally, the Guam EPA Board of Directors has mandated and motioned that the agency raise awareness on the bill's potential impacts on the initiatives in our proposed rules and regulation for the Recycling Revolving Fund. And he lists initiatives such as the Recycling Industry Economic Stimulus Program, Mayor's Council Guam Environmental Cleanup Program, Beverage Container Recycling, Green Waste and Disaster Debris Management, and our overall efforts to combat illegal dumping may see some form of impact upon implementation of the bill. And we all know during election season, the number one question that gets asked is, what are you going to do about illegal dumping, Senator? Right? And so we give the best answer that we can, and we defer to the mayors because we allocate and appropriate that funding for them. But now, if any of us should decide to run again and they are asked, Senator, what are you going to do about illegal dumping on our island? We can refer to the hard work that your team did under you to the recycling revolving fund initiatives. And so that great work that you did, I didn't understand why it's almost like a very divisive letter, and it almost seems that this deputy director perhaps seems some kind of reprimand, but I wanted to know what was the purpose of rescinding a very direct and straightforward letter from the deputy, because I really did not see any harm in it, and he does mention what the chairman stated, and he begins the third paragraph with the very thing that the chairman stated. Impress upon which you highlighted, or someone highlighted for you that sent it part of this email, impress upon the legislatures the effect the proposed measure would have on the agency's plans with the RRF and other programs that we are seeking to implement. And so I'm trying to understand, what was the purpose of rescinding a letter when this letter was very straightforward and forthcoming?
Thank you, Senator. The reason for the rescinding of the letter is twofold. In the letter, we stated an AG opinion which we never officially got memorialized. So in effect, this being organic or inorganic, we should not be stating that unless it's been memorialized by the Attorney General's office. That is not our place to state. The other thing is, it mentioned that it was a board motion. Motion is more formalized, also memorialized, and signed by the board chair. That was just the recommendation. So these two factors.
I'm sorry, can you repeat the second one, please?
The board motion, it was stated it was a board motion.
Board motion.
And that would be memorialized and signed by the chairperson. We did, in lieu of just us informing the legislature, this body. And so that's why the rescinding of the letter. Those two factors that we wrote or expressed it wrong in the letter, it needed to be rescinded.
Okay. I understand for the second point. You're saying that the board should have been the one to write this letter and not the deputy? Is that what you're saying?
As a board motion, it needs to come from the board and signed by the board chair, correct?
Okay, so the board needed to be the one to put this information out.
And because it did not come from the board, and because the board only made it a recommendation that the administrator or my acting expressed that to you, it should not have never been written out as a board motion, because it was not a board motion, it was a recommendation.
And then the first motion was, the first reason was?
We were stating an Attorney General's opinion, which we did not have memorialized, and so us to put that in writing in our letterhead is not our place. It needs to come from that, just like the board, it should come from the Attorney General, and that's what we should reference. And since we never had anything on hand, we shouldn't be referencing that.
I see. Well, it's in the minutes, it says the chairman stated that the issue, which is this bill, may be moot. They put maybe a moot point because the AG testified that it is inorganic for the legislature to direct the executive branch on how to construct the contract and dictate all the terms of the contract. And the second point, that the current legislature could not bind future legislatures by actions of the current legislature. But in defense, you know, I'm going to reveal everything if, just bear with me, Mr. Chair. So already they mentioned the AG's position. And then it goes further on to say, the administrator clarified that the RRF was not funding for Guam EPA's use of organizational income, but it is used for everything else outside of it. So none of this money, really, a large portion does not go to EPA. This money goes to the community because it's the community, the people of Guam, that put the money in to move forward with a lot of the recycling initiatives, illegal dumping cleanup, white goods, disaster recovery of debris and waste. As administrators of the fund, the agency can't use the funding for enhancement purposes or for its employees outside of what it is already written in statute. So whether the RRF is used for Mr. Bello's annual payments or for other purposes, the use of the RRF will not fundamentally impact EPA, but it will impact all the programs that the Recycling Revolving Fund Rules and Regulations was developed, which is now you're having your public hearing tomorrow for public comment. However, it will impact our ability to do some of the projects for the island of Guam, recycling programs and community outreach. The chairman deferred to the position of the Attorney General and her legal expertise on the measure. And then he further stated that during his confirmation hearing, he was asked his position on the proposed measure, to which he replied, "If you owe the money, you should pay him one way or the other. But we have uses for that money within Guam EPA. We have different components at the Recycling Revolving Fund that we are going to be needing to do and needing to pay for." And so I was just wondering what was the purpose of that. And Mr. Harecki, this question is for you. You stated earlier that, and just bear with me. Where is it at? You stated earlier that all the elements of the contract are there. And so if all the elements of this licensing agreement or of the contract are there and present, then why are we trying to propose a bill that changes a lot of the fundamentals of the license agreement if all the elements of the contract are there?
Thank you, Senator. First of all, for the contract amendments, actually those aren't required, so they may or may not become a part of the contract. That would be up to the CLTC. So I think the original agreement could well stand on its own. I don't really think that there's anything really being changed about the license agreement. The agreement had all the elements of what the services were worth, what the value was, and remember too, this license is in effect to either 2023 or 2025. In other words, it's still a valid binding agreement. It's still in effect. And that's possibly another reason why we never felt that a Claims Act claim was appropriate, because the contract's still in effect. As I previously mentioned, every representation I have ever had from any CLTC director was they agreed with our position. I should mention regarding the contract amendments, we didn't just create these. These were all discussed with at least 2 directors of the CLTC. They were first discussed in 2011 with Monty Mofness and the chairman, Oscar Calvo. And they were negotiated, in fact. Some of these amendments were their amendments. They didn't come from me. So we had a very cordial back and forth where they requested changes, I requested changes, and we then, orally at least, we did agree. We had a meeting. Everybody said the contract amendments are fine. But then, unfortunately, Monty Mofness got sick, later passed away. Then when we came back 2 years later, or no, 3 years later, to CLTC Chair Borja, again, we discussed the amendments. My recollection is that Mr. Borja thought that the amendments we had offered were fine, but his concern was because of all the controversy about the CLTC, he wished us to go to the legislature to get authorization so that the CLTC could enter into those. So that's why, basically, that's why we're here, because we were asked to do that, and we're interested in moving this contract ahead. So I don't think the amendments are really something that was already discussed, but I'll maybe discuss that a little further later.
Thank you.
I hope that answered your question.
Yes, it does. Thank you.
You.
I want to bring up a letter that the chairwoman of the CLTC wrote on November 1st, 2018. And in this letter, we go down to the third paragraph, and the last sentence, it says, the agreement was for the cleanup of existing metallic solid waste on CLTC property. Nothing else, just specifically for that. And then you mentioned that about the amendments, and they were, the license agreement can stand on its own. But then she writes, while the amount of solid waste removal and disposal service conducted by Cocoa Recycling during this period is very credible, CLTC does not possess the actual documentation for the services performed, for all the services performed. In October 2011, Cocoa Recycling approached CLTC at a regularly scheduled board meeting to request an amendment to the license agreement, seeking a change in the compensation to recognize the amount of the removed solid waste. The Board of Commissioners, pending documentation, because there's no documentation, that's what I'm thinking, did not act on the amendment. Based on the monthly rental fee for the full term of the license agreement, Cocoa Recycling owes CLTC $1.591488. So that's $1,591,488. This is the only amount considered acceptable as a credit in exchange for the rental payment as permitted in the license agreement. This is the only amount considered acceptable as a credit in exchange for rental payment as permitted in the license agreement. And so it goes on to state different pieces of the legislation, and in a sense almost arguing the exact opposite of what the legislation proposes. And if I can just read through some of these, Mr. Chair.
Senator Nelson, is that a part of the hearing on the bill, or okay?
Yes, yes.
Okay, absolutely.
It refers directly to Bill 350.
Was that transmitted as testimony for the public hearing, or
CLTC
was it?
testimony
Okay, thank you.
on Bill
You may proceed.
350-34 dated November 1st, 2018.
Absolutely.
Additionally, the following items are of concern, and this is why I'm reading this to you, because you said that my understanding was that the license agreement can stand on its own. Page 4, line 9, this is what we're adding. Pursuant to Section 2, term of the license agreement, the parties agree that the initial term of the license agreement shall be deemed to have commenced on September 4th, 2005. Jump in. Okay. Clearly, the opening line of the license agreement states effective date as July 1st, 2001, while Part 2 term states the term of this agreement, commencing within 2 years of the date of the execution of this contract. There is no date with the executing signatures, and only a date placed by the notary. There is no date with the executing signatures and only a date placed by the notary. The Commission contends the commencement date is based on 2 years from the effective date as of July 1st, 2001, as shown in the opening line on the first page of the license agreement. The title also expresses the agreement execution in 2001. Therefore, the commence date should be July 1st, 2003. Page 5, line 12, licensees shall be authorized to conduct the following business activities on the real property. Lot 5219-1-1, Barragata, Solid Waste Processing Facility, Solid Waste Management Disposal and Recycling, Hard Fill Storage and Warehousing, Operations of Construction Office and Storage and Sales of Construction and Building Materials, and Equipment and Laydown Yard. The inclusion of additional activities to this license agreement such as construction office and storage and sales of construction and building materials and equipment and lay-down yard, was never an intended purpose for this agreement, nor has it ever been a discussion item presented to the Board of Commissioners and should not be included in this bill. Page 6, line 2, CLTC and licensee may negotiate for the exchange of another property in substitution of the property licensed herein. Any such substitution must be mutually agreed upon by the parties. In the event that the parties agree to the substitution of another party, the credit currently due to licensee shall be transferable to such other property. With the limited time remaining on the existing term of the license agreement, and based on its purpose, this is what the chairwoman writes, and based on its purpose was a waste processing facility. It is not in the best interest for the CLTC to exchange or substitute the licensed property. The licensee should devote the remaining term of the agreement to restoring the property to an acceptable and usable condition. So I'm under the impression by this that the property is not in an acceptable and usable condition because of the waste that was placed there by the licensee. Page 6, line 12, statutory creation of CLTC credit. There is hereby established CLTC credit of $1.6 million to be used by the licensee in lieu of cash payments to CLTC, and in order to satisfy the terms and conditions of subsection 75-122 Charlie 21 Supra. Such CLTC credits established herein shall not be assignable to a third party or parties and shall only be used by the licensee against any rental payments that would otherwise be due to licensor under the amended licensee agreement pursuant to this act. Furthermore, CLTC credits established herein shall remain valid and lawfully binding until fully redeemed pursuant to this act and shall be honored by the CLTC accordingly. This is page 6, line 12 of the bill. Her response is, the specific rent credit that should be authorized should be the exact amount which covers the period of July 1st, 2003 to June 30, 2023, which is $1,591,488. Likewise, CLTC will not and should not be held liable for any other costs or expenses regarding this license agreement. The CLTC credit is not a form of currency to be granted to the licensee. The CLTC credit is not a form of currency to be granted to the licensee, but rather an authorized accounting credit to a receivable on the monthly rental fee, past, present, and future. Any unused portions of this credit shall be deemed null and expressed accordingly. In no way shall this credit be expressed as an assignment, nor shall it ever be assignable towards another interest, such as another licensee or property. And so this is where, with all due respect, Mr. Attorney Harecki, this is where I want to beg to differ with you that the license agreement cannot hold on its own, because here we are making significant changes to the licensing agreement, whereas even the purpose of the whole licensing agreement was to do services in lieu of occupying property, not to do services to gain hard cash. Thank you, Mr. Harecki.
Okay, thank you, Senator. First of all, I could say that that letter was never transmitted to me. But the way this bill is now, all those provisions of amendment, they're not mandatory. So I suppose even if this bill passes, the CLTC could then say, no, we don't want those amendments to the contract. Nothing would prevent that, actually, under the way the bill is now. But I can tell you that her position is completely contrary to every director that I had ever spoken with previously. as I mentioned before, these were negotiated with Monty Mofness and Oscar Calvo. They were back and forth. We agreed to the provisions. They were okay with them, and they said they were going to sign them. They didn't. I know that is problematic.
I
but
understand. Yes, that is problematic.
I'm telling you, we had discussed it and negotiated, and the same thing with CLTC Chairman Borja. We presented the amendments. Again, I don't believe there was any substantive disagreement. But if you are right that the CLTC does not like the amendments, they'll still have a remedy, even under this bill. But I want to make a couple of points, because I think she's absolutely wrong. First of all, the effective date of
Mr.
the license.
Horecki, we're not going to be debating the statements that were brought up in the letter.
You don't want me to respond to any of the particular
I don't think
allegations?
I asked
if
a
there's
question,
a specific
Mr.
question,
Chair.
I'm
I
sorry?
don't think I asked a question after that because...
Right. If there's a specific question with respect to some of the issues that are brought up, then absolutely. Another member may posit it as a
Thank you,
question,
Mr.
Mr.
Chair.
Horecki, but we're not, again, I'm being consistent with avoiding prolonged debate unless there is a specific question that needs to be
All
answered.
right.
Thank you, Mr. Chair.
Senator Nelson, are you satisfied? Any other senator wish to be heard on this second round of questions? Acting Speaker Terlai.
Thank you. I guess I wanted to ask the administrator of Guam EPA. So according to your plans for the recycling revolving fund, part of it is
I'm right behind you.
to be spent on the Mayor's Council of Guam Island-wide Environmental Cleanup Program. And that's in your rules and regulations, and you spell out what that's going to be used for, and it's pretty much for remove, recycle, dispose of solid waste in the villages, right? Report all recyclables collected, and generally like that. And the letter in 2017 where you talk about these rules and regulations, you specified the amount of approximately $400,000 to dedicate for that, for the mayor's portion of your big plan. And so I guess I'm still looking at this bill that's talking about taking $598,000 every year, you know, out of this fund. And so I'm wondering if we took it and that would, well, I guess I'm going to ask you this question. The Mayor's Council rep is not here, but the Mayor's Council of Guam submitted testimony saying they are in favor of paying this owed debt because it's going to better their reputation, and that way they will be able to better contract in the future. But I'm thinking if we take, I asked this at the public hearing, and the mayor was not able to really answer, but if we take the money away from, you know, the people who are supposed to be giving it out to the mayors, or we're taking it away from, you know, the villages for past debt, what happens to these villages tomorrow? I mean, I'm really concerned about that because we've given them the entire sum in 2018, and you are proposing to give them at least almost $500,000, $400,000, almost, I mean, less than the amount that's being taken out. And so I'm just wondering, is it foreseeable that that this money might not get to the mayors and to the villages for the cleanup that we know they are doing? And that's why I was so very confused and concerned, because we know they are actively pursuing getting this debris out of their villages, white goods especially. I don't know, do you have any thoughts on that?
So thank you, Senator. So one of the things that maybe I didn't state earlier was that when you referenced those numbers initially, that's what we were trying to do on the front end of writing these draft regs, is put a monetary value to them and say, this is how much it's going to go. In tomorrow's release, in the public hearing, you'll see all those numbers removed, not in any effect tied into any of the discussion or the need for money today and in front of this body. what it became, like I stressed earlier, is to give the administrator free rein and opportunity to determine if, so be it that, for existence, the mayor's office, if we only gave them 400,000 when this body has given them 2.2 million or whatever the amount is. At some point, maybe in the future, maybe because of an emergency or something, maybe the mayor's office would be the most beneficial entity to get money from this fund. And so that's why we don't put in our new draft regs a monetary value per assigned venture. With that being said, I can't speak for what the mayors do or they say. We do see that there is value giving money to the mayors because though they've not always been expending that funding immediately or in due course, there is good that comes out of it generally. And so that's just one of the things that we're trying to address with the draft regs, rules and regs.
I also wanted to ask you, in the earlier renditions of this bill, there were, we had public hearings, and at one of the earlier hearings, the licensee, or maybe it was Mr. Hareki on behalf of the licensee, stated that he was unable to return the Barrigada lot in an environmentally safe condition unless the government of Guam pays him an additional amount of approximately $400,000. Thus this bill, right? Or that's one of the rationale. And then, as was read by the preceding speaker, in testimony, I was curious about that. And so the Chamorro Land Trust chairwoman's testimony also says, the licensee should devote the remaining term of the agreement to restoring the property to an acceptable and usable condition. And so then I found some correspondence between EPA and Cocoa Recycling where they talk about, since 2003, there's back and forth, 2003, 2004, about the use of this property in Barrigada, the one that they are leasing from CLTC for the $6,600 a year. And there's back and forth talking about an agreement of involuntary compliance, noting Cocoa is, quote, allowing to be placed these solid waste materials at lot number 5219-1 Barrigada with an expired storage permit and is improperly managing and operating solid waste management facility. As a result, Cocoa agreed to pay payment of $1,000 to Solid Waste Management Fund. December 30, 2003, EPA letter to Cocoa requiring them to submit an incident report regarding a tire fire on 2 separate occasions in August and December 2003. In July 2003, EPA letter explaining notice of violation and order of compliance. March 2004, follow-up letter from EPA noting that incident reports on tire fire were still not received. Another March 2004, Cocoa responded they will work with Sumitomo to stop construction debris being inappropriately dumped at that site because the permit was only for a tire facility, tire recycling facility. April 2004, EPA letter to Cocoa. Cocoa provided assessment and sampling plan for the tire fire. In EPA states there is great likelihood of contamination on the site and that the sampling plan as submitted is inadequate to delineate the extent of the contamination on the site. May 2004, EPA revokes tire processing permit for Cocoa Recycling. There's a letter of violation, original agreement of voluntary compliance. December 2003 was cited again and a deadline was set for June 2004 to come into compliance. I couldn't tell from the correspondence I had. So this property, when it was leased from the Chamorro Land Trust, they were given a permit to operate a tire, is that a recycling facility, or what was the permit for?
Give me a second, Senator, so I can read our...
Sure.
So the notice of violation that you're referencing in 2003 was for the solid waste processing facility up in Barragata Heights, which the fire caught, or which the tire processing facility, which is the solid waste processing facility, caught on fire. That's the site referencing in the NOV for 2003, correct?
What is the current status of this property? Because the Chamorro Land Trust Commission chairwoman seems to be concerned that they've leased it out. I think the lease is supposed to expire in 2023 if this bill does not pass, and she seems concerned that it will not be cleaned up by then.
So the property that has been referenced in that notice of violation is still not in compliance at this time?
An outstanding notice of violation?
It is, Senator.
Is the AG's office aware of this outstanding notice of violation?
I'm personally not. I'm not sure.
Senator, we are aware of it. We're not handling it at the AG's office. That's at the agency level.
Are there potential penalties pending?
So generally, I wouldn't venture to say yes or no to that, because generally the way we work and conduct notice of violations is to try to get them into compliance to remove the environmental issue. And then at that point, then we can go ahead and move into what type of penalties are. So with this notice of violation not being in compliance, there is the potential of fines being assessed to the company.
Would you be able to give us an estimate how much money it would take to clean up this property if we had to start tomorrow and clean it up before 2023?
That I don't have an answer, because it would be best, it would be determined by the assessment, which we have not at this time have approved that it's been an appropriate assessment done on the site. So depending on the delineation of contamination, if any, is going to determine the cost of the cleanup at that point.
It seems from the correspondence that there hasn't been a thorough evaluation of the contamination, but that there is potential that this property is contaminated. Definitely, cleanup is required. The bill suggests that, says that we're going to put aside, while we're paying the $590,000, that we're going to set aside $300,000 to ensure that it's cleaned up. But there's a very limited, well, I don't know. I guess I'm curious. We have really nothing to tell us whether that amount is adequate to clean up this property, especially, based on the correspondence I've seen, and I'm curious even what the Chamorro Land Trust is thinking about doing right now in light of this existing notice of violation, the years and years of not being cleaned up, and if this bill does not get passed, what recourse they have. But I know that, so, at the hearing, we were being told by the licensee that this is why we have to pass this bill, so that they're going to get some cash and some money in order to clean up the property. But I don't know. That seems a little bit not in good faith to me when they were contracted in the first place to clean up, and that they would potentially leave this property, worse than when they first got it is, I think, of great concern to us. And it seems like, I don't know, almost like something being held over us here at the legislature, right? That we're going to be left with a dump if we're not going to pass this bill and allow them more money, in addition to the $1.6 million of credit that they've received, or they will receive up to that point. In other words, we're not going to get any cash from them if the property's left not cleaned up. yet we are, we're giving them credit in lieu of rent. But in addition to that, they're asking for cash on top of the credit in lieu of rent. And so I guess that brings me back again to the AG's office. And when I looked at the license agreement, it talks about $6,600 monthly rent for 21 years. And it talks about how much credit they would get per ton. But nowhere in this document did I see $7.5 million or any figure like that. In fact, not even the $1.6 million is stated there as the maximum or anything like that. But then I looked at the minutes of the board meetings, the Chamorro Land Trust board meetings, where they supposedly approved this license agreement, and nowhere in those board meetings, when the license agreement was being approved, they talked about the rental amount, but they never talked about the potential liability for $7.5 million, that the Chamorro Land Trust, and because I was so curious, I wanted to see what these commissioners might have been thinking, that they were going to incur a liability of $7.5 million for cleanup of the island of Guam, and they were going to take that on, from the meager fund. That's way more than their legislature has ever appropriated to the Chamorro Land Trust Commission in the year. It's way more than Chamorro Land Trust had in its funds back then, for sure. And so, the document does not state any other source of funding for this, proposed liability of $7.5 million. And I'm thinking, if anybody did that today, and I just can't see how they would be able to come to the government and say, you didn't sign a contract for $7.5 million, but you owe me $7.5 million. And we require our contracts to be certified, showing that the funds are available, showing where the authority comes from to even incur this kind of amount, and very specifically how it will be paid, or they're cancelable. And I don't know. So when I looked at the minutes, there was no discussion. The commissioners at the time, I think, were not informed that they were signing on to or agreeing to anything like what is being talked about today, 17 years later. That was actually not a contract for $6,600 rental payments. It was actually a contract. We're being told to believe that it was actually a contract for $7.5 million. I don't know. I find it really incredible. And so I guess I'm going to go back to you.
Mr. Chairman, can I just say a point of information? I do have information to share that would answer the good speaker.
Senator Rodriguez, what we'll do is we'll allow you to make your statements on a closing level on the round 2.
Okay.
But I did want to raise a point of order with respect to the Attorney General's office did state earlier they have not reviewed the license agreement. That's already on the record. So just as an advisory, before you posit your question.
Thank you.
Okay.
Yes.
I'd like to clarify that. I said I had not reviewed the license agreement. I'm just the litigation deputy. I do court cases. Other people within the office may well have reviewed the document.
Okay. Mr. Urquhart, are you informing this body that there are individuals in the Attorney General's office who could be answering these questions that are not present here?
No, I'm not saying that. I'm saying that I'm the litigation. I'm talking about my own personal knowledge. You said our office had not reviewed it. I am not sure.
It is the intention of this whole committee of the whole to have members of the Attorney General's office here to be able to answer the questions with respect to the license agreement. The communication from the Attorney General's office all day has been the license agreement hasn't been reviewed. We've had Senator Rodriguez asking questions about it, other senators asking questions about the license agreement. Are there individuals in the AG's office who could answer questions about this license agreement or not?
I am not aware of that. I'm here to answer questions about the
Mr. Chair, I think they said earlier that it's there has been no claim submitted to the Attorney General's office that would trigger a review by the Attorney General's General's Office of a claim. And there's been no litigation filed in the Superior Court of Guam, which would trigger again the response by the Attorney General of Guam on behalf of the Chamorro Land Trust Commission or all of us as to that. And for those purposes, they've not reviewed this.
But I think, Mr. Chair, too, it's important to note in the hearing that the AG's client is the Chamorro Land Trust. And so their Deputy Attorney General sits and represents the Chamorro Land Trust and should be aware of what's happening. The director went on record saying that this has been discussed in previous meetings and have been part of the minutes. So that's very important to be able to put on record. And also, you know, our commissioners back then were not as ignorant as we think they were. In the agreement itself, there's a formula that 25,000 metric tons and at $20 per cubic yard. So that's where you're going to find the 7.5 million. So to say that our commissioners don't know what they were doing perhaps in the past, it's just not the case.
We will open the floor after we dismiss the panel for the members of the body to be able to debate back and forth with respect to the answers that we get here. My concern to my colleagues is I've been sitting here all day, and I don't know if I've been listening wrong, but the communication I've been getting from the Attorney General's office was that they're unable to comment with respect to the license agreement.
Mr. Chair, now you're debating.
And now I'm getting feedback from the Attorney General's office that now they do have individuals within their office that can comment to the license agreement. And so I wanted to yield to the members of the body. Did you wish to have such individuals requested for this committee of the whole, or would you like to continue to proceed with these circumstances?
Yes, Mr. Chair, if I may, I believe it's very important, and that's who I thought would be here, is a representative who could answer these questions and who's familiar with this, because during the public hearing I did ask who was the attorney for the commission, and I was told that it was a member of the Attorney General's office. I don't know who that is. Maybe the deputy can inform of who that person is.
May I, Mr. Chair? Mr. Chair, I agree with Senator Chalahi in what she was representing, in that when the questions were asked of us whether or not we have reviewed the license agreement, it was in the context of whether or not that there was a claim filed ever, and that whether or not we reviewed it in the context of determining liability or anything like that. I have read the license agreement just before, so the hearing, to prepare for the hearing, to know what's in it, but not for the purposes of making an analysis of the determination of liability or anything like that. And it's our position that that's not something that we would occur and give a tabletop type of opinion on that respect. It's the type of process, which is what we're talking about here, that we believe a claim, if it should be filed, would go through. And so it's not so much that we've reviewed the license agreement. This license agreement was executed back in 2001. So, but in terms of, our point here is that the legislature here is determining liability. Our point here is that there's a process to do that. And that's not something that we would do on this table here. That's something that would be done through the process.
Mr. Chair, if I may just ask, so who is the representative that sits with the commission? Is it a member of the Attorney General's office?
Yes, it is.
Okay, so that individual should know what's happening, because the director did state for the record that this has been discussed in the commission. And again, I want to just remind everyone, we're here because we were approached. We were told that the commission had said we need legislative action. And so somewhere down the line, I'm hoping that the Attorney General's representative who sits on the commission is aware of this and could be that proper individual that should have been here throughout this whole process.
The chair will yield to the members of the body if there's a formal motion that wishes to be made. My interpretation of this whole proceeding is that this entire bill is a question of liability. And if we're going to be discussing whether or not this is in fact a legitimate liability and a legitimate way to remedy it, then we would expect, or at least I would expect, that the Attorney General's office would be able to answer that. To this point, the Attorney General's office has refused to comment on the license agreement and now has just opened the door to being willing to talk about it within a limited context. And now has further opened the door and informed us that they have reviewed the agreement, but now have not commented thus far as to whether or not the liability is legitimate. And that is a key question for this body. And so I wanted to yield to the members. Is there a formal motion to request for the Attorney General to be more elaborate with respect to the liability, or to continue proceedings? Senator Esteves, you recognize.
Mr. Chairman, I'm going to have to concur with your sentiment and make the motion. I mean, I was under the impression too that representatives from the Attorney General would have had the initiative to put the work in. I mean, considering the size of the budget they receive, and they have an attorney assigned to work with the CLTC, and to come before this body and say, I don't know, I think is a disservice to what we're trying to do here. I think liability is very important. And as previously stated, regardless of how the vote goes, whether this ends up before the courts, either way, it would have to come before this legislature for an appropriation in whatever direction it goes if liability is found, whether preceding a court filing or this body takes action. So I think these are definitely questions that should be answered by the attorneys general, at least, you know, baseline or cursory reviews, to be able to provide a little bit more than I don't know on the taxpayer dollar. Thank you, Mr. Chairman. So I make that motion that we do get the person who would be able to provide more information regarding the lease agreement
Point of order, Mr. Chair.
You may state your point of order, Senator Nelson.
Thank you. The Deputy AG stated that there's a process which is in regards to specifically for this, that you file the government's claims and then you go to the Superior Court process. Now, he stated also that what was in question was the licensing agreement, if in fact it is valid.
Senator Nelson, you're rising to point of information?
Yes, and the liability is if the liability is in question. So my question is, I know that we make policy, but we're not attorneys and we're not the court of law. And so does this body even have the authority to move the AG's office to put in, opine a decision that hasn't even been raised within the courts in this manner? Because this is a licensing agreement, essentially a contract. So what is our left and right limits to do such an act?
Your point of information noted, Senator Nelson. Your motion is well received, Senator Esteves. The reason why the motion is being entertained and the reason why the question is being asked is because this body has to make a decision with respect to whether or not we're going to entertain this agreement in redress of the liability. And so this body has called the Attorney General's office before it in the Committee of the Whole to answer questions with respect to this liability. The initial responses were that the Attorney General's office has not reviewed the license agreement, and now I'm being told it's with respect to evaluating liability, as they want to be blind to that, but they have reviewed the license agreement at large. And so the motion before us now is to have the Attorney General's office be open to commenting on the liability questions with respect to the bill, and to if necessary, summon whomever they need to before this body to be able to answer those questions. Is that correct, Senator Esteves?
That's correct, and I'd like to put the motion before the body. I mean, I think if the body makes the consensus that the AG be able to, if we were to trigger, I guess, a response or work from the AG to go to work, basically, and formulate or opine on the situation, I think that would compel them to do so. I guess that's the only way to get them to put the work in. So yes, that's my motion.
Point of information, Mr. Chairman.
Senator Espadon, you recognize.
Mr. Chairman, this motion is, first of all, we're here in the Committee of the Whole to find out certain things. We have a very limited time before this body is going to be replaced. To expect the Attorney General's office to put in the diligence and the work to be able to come back and make certain determinations on the facts of this case that go back 17 years, I don't believe will happen within 24 hours. I don't believe it's going to happen within the next 3 or 4 weeks before, by the time we leave here. And so I just have to question, why are we even entertaining this kind of a motion? The initial statement from the Attorney General's office was that their opinion is that this piece of legislation is inorganic and unconstitutional. That's the very threshold I think we need to get through. If it's unconstitutional, why are we even entertaining it? When we first entered this office, we took an oath to abide by the Constitution of the United States. We took an oath to abide by the laws of the United States. The Attorney General has given their opinion and has stood firm on their opinion that this is basically inorganic and unconstitutional. And now we're going to ask them to go do some work on a piece of legislation or on the history and the factual case, the facts of this case that go back 17 years, maybe even more, right? When at this point in time, their opinion is, this is not organic. I oppose.
So you're not rising to point of information, you're making comments with respect to the motion.
Well,
and
the
that's an
point of
objection.
information was that what was stated by the Attorney General. You know, and so maybe my opposition is misplaced at this time, but the point of information was the constitutionality and the inorganicity of this piece of legislation. And for them to do anything more when they've already opined that, you know, that this does not pass muster, constitutional muster, kind of like, where are we going with this?
So you're registering an objection to the motion?
So in that sense, I am registering an objection.
We'll open the floor to further discussion on Senator Esteves' motion. I'll recognize Senator Torres and then Senator Rodriguez.
Mr. Chairman, I also concur with some of the sentiments that have been expressed this afternoon as when we reconvened at 2 o'clock. What was confirmed to me when I was inquiring about the nature of this liability is, I believe, was answered by the chairman of the Chamorro Land Trust Commission, the director. Whether the liability is $7.5 million or $7.50 is irrelevant at this point, particularly to us. And if there was a challenge as to what the amount of, and whether there is, that's an administrative decision and not ours. But I believe also that, what we've been told as a body is that the remedy for satisfying any liability, whatever that liability is established in the license agreement in the form of a trade-off, that in exchange for compensation you will be given, it's an offset, excuse me. There's an offset against rent, and that is the compensation mechanism here. Because I had asked very specifically, when we're floating around a dollar amount, how did we arrive at a dollar amount? The dollar amount was the value of the services. But the repayment that was anticipated early on when the license agreement, as I understand, and please correct me if I'm wrong, as I understand from what's been presented, is when the license agreement was signed in 2001, it was contemplated that any services that were rendered for removal of metallic waste, debris, tire waste, and such was going to be offset against rent that was owed to CLTC for use of the land. So I really goes back to this whole issue of whose business is it right now to work out whether it's an administrative remedy that has to be satisfied with a settlement agreement, or it's a case that requires judicial review that's going to be settled through a judgment. Whether it's that course or that course, my point has been, is it really within is it our course to do it? Or does this belong more reasonably in the administrative body or in the judicial body and not the legislative body? So liability, I think, is irrelevant here. We're not here to decide liability because whatever that liability is, in the license agreement, it's already contemplated that that liability is to be satisfied by a certain mechanism. And I don't think we're disputing that, are we? So we're throwing around this money figure, which I think is confusing everybody, because that's what's setting us to this thought that we've got to pay back something. But that payback has been contemplated from day one. The circumstances that transpired, the scope of services, I think, went wacko and unfairly to cocoa recycling, unfairly. But that's for the bodies responsible for that injustice that they did to cocoa recycling by not compensating them or going beyond a scope that could not reasonably be satisfied. To expect that the repayment is going to occur over an offset that's going to take them 90 plus years, that is darn unreasonable. But that's not our burden or our fault to fix right now. I think that we can be the last resort after the more proper channels have been exhausted, which is the administrative body, which is probably in charge of this whole issue of having it come to this point after 17 years. Or if no other course, we go to the judicial branches, which is what we do when there's challenges between the two and there's no way of determining. So I just want to, and that's why I keep going back to what exactly we're talking about. It's extremely complicated, and it breaks my heart because Guam has been done a good deed through cocoa recycling. And we owe the Bello family an indebtedness for all the cleanup efforts that they did, especially post-typhoon, or even curing the backlog of this horrendous dumping that we have on island, illegal dumping. And that's notable and that's admirable, and I hope that we can bring justice to them for all that they contributed, and they were shorted because they entered into an agreement for something that was perhaps a small scope, and out of the generosity of their heart and their desire to help the island when the island was in a bad way, as we do all the time on Guam. We jump in and we donate, and we don't even think about being compensated, and we help out. But, you know, there comes a point where you want to be fair to good people like that. How do you become fair is another question. How do you make it whole is another question. And I think that where we're going here is we're not letting those people responsible for creating this situation that puts cocoa recycling in a very awkward situation to try and seek remedy and fairness and justice to the company. We're not putting that responsibility for cleaning up that derailing of a probably a very narrow and focused license agreement on the agency that's responsible, which is the administrative branch. So I wish that we could just fix it so easily after 17 frustrating years. I wish we could, but I fear that the method by which we are approaching this perhaps is not the most prudent and is not what's contemplated within the scope of the respective branches of government. And that's all I'm cautioning us. We need to make cocoa recycling whole. I think we need to own up to the responsibility to pay people who jump in when there's emergencies and situations where people with the wherewithal and the equipment and the mechanism to help out jump in to help the island. I think that's what's really paining me about this situation is I don't want to ignore and say, well, tough luck. It's 17 years too late. That's a horrible situation to be in, and I really feel for the family. But at the same time, too, I know that we are also looking at potentially saddling EPA with a $5.9 million burden that is not sustainable for their immediate goals and projects. So I don't believe the motion is necessary, and I think we need another recourse. And my sincere apologies to anyone I may have offended, but I think that we have a very bad situation that we need to put the onus on the right agencies to clean up their act.
Senator Torres, any other members wish to be heard on the motion from Senator Esteves? Senator Rodriguez.
Thank you, Mr. Chairman. Mr. Chairman, I, of course, support the motion. The retiring speaker has always been, for me, at least, the voice of reason in this hall. And so I appreciate her statements. Mr. Chairman, I believe we are at that point in time where it's now up to this body to move this forward. As I said, I'm going to reiterate again what I said. What I keep on saying is that we were approached by an executive agency to move this issue forward. The question of the separation of powers, and I respect the Attorney General's office, and that was an opinion or guidance that was brought forward during the public hearing, and again was reaffirmed. This was affirmed today. However, I want to remind our colleagues that our own legal counsel, and and we had 3 iterations of this: Bill 98, Bill 228, and now Bill 350. Never has the separation of powers issue ever been brought up with by our legal counsel. As a matter of fact, as you all know, that we did receive guidance or a memo from our legal counsel about a whole nother issue, but that issue was raised earlier during Committee of the Whole. And so, although I respect, of course, I always do respect the Attorney General's office, we must also put faith and respect what our own legal counsel has brought forward as a guidance for us as well. And so my support of this motion, Mr. Chairman, is really based on the fact that this issue was brought forward by the executive agency. The executive agency is represented by a member of the Attorney General's office, and so must have information or understands this issue. And so that's who I thought would have been here during the Committee of the Whole. And so that's why if we are to move forward and this motion does pass, then I believe that is the most prudent way to move forward. If it fails, Mr. Chairman, I would proffer to the body that we continue as you have set out the ground rules, and that we as a body move forward and make a decision whether we're going to move forward with this or not. Thank you, Mr. Chair.
Thank you, Senator Rodriguez. Any other members on the motion? If none, Senator Esteves, you're welcome to close.
Thank you, Mr. Chairman.
Mr. Chair, point of order. Speaker Tulahi was raising her hand before you called on Senator Esteves.
Senator Esteves, I recognize you. Do yield to Acting Speaker Tulahi? Acting Speaker, you recognize.
Thank you. On the motion, I'm just trying. The motion, to me, really highlights what we are doing here. We are, as a legislature, trying to decide the liability of the government of Guam where it has not been decided by our representatives in the Attorney General's office. Normally, they will go to court, they will defend us, they will do whatever they have to do, and then they will send us the bill. They'll send us a letter that says, we've made this agreement, the courts have ordered payment, or whatever mechanism, or that, you know, we've settled a claim and we need more money. And they will tell us what we need to do as a legislature in our roles. And the problem with the bill that I think the motion highlights is that what we're doing here is the reverse. First of all, they're telling us it's premature to act on this bill without knowing liability, and that we are not able to determine liability while this bill's folders are in front of us any more than they are. It would be a very complicated procedure, because it would require the plaintiffs, the person who believes they have been aggrieved, to be the one to file their claim. Filing their claim would require them to prove why they are owed. We are sitting here listening to testimony about letters and different things, and I'm expecting that the Attorney General, when it comes to their office, is going to say half of these things are not even part of what they will consider as to whether this contract is valid or not. Because I mean, you know, those are things that we are making so many assumptions about, and we are kind of hearing one side. So we're hearing why the one side believes they should be paid, and we're hearing all kinds of evidence thrown in there, but I'm not sure what evidence is really proper to be considered. And so I think the motion would put the onus on the Attorney General's office to do what they have said cannot be done until a claim is filed, litigation is filed, or something else is filed that prompts the government of Guam to determine liability. Otherwise, it's pretty much a gift that, notwithstanding our inability to determine liability, we are just going to give them a gift because either we feel sorry for them that they incurred the work, or we feel for whatever because of, you know, statements that were made between the parties, and I guess the legislature can do that, but I, for one, do not feel comfortable doing that. I would like, if we have a legitimate obligation, then we can consider that, and we can get advice from the Attorney General as to what those parameters are. And I think it's just premature for us, and that's why why should we send this to the Attorney General's office like this? We can't even get the answers for ourselves. The record's incomplete according to the Chamorro Land Trust Commission's testimony. Even they do not have all the records that they would need to confirm some of the allegations that are being made. And we keep talking about whether, you know, the lawyer for the Chamorro Land Trust is here or was present at their meetings. But again, the Chamorro Land Trust has not approved any amendments to their license. They object to us dictating any amendments to their license by this bill. And that's what pretty much they have told us, and we can guess whether that's at the advice of their counsel or not, but regardless, I mean, their counsel is the same that we have in front of us. These are all representatives of the Attorney General's office, and I hate that we would so blatantly disregard what they are advising us. And I think it's clear that they are advising us that our proceeding with this bill as is going to perhaps create a liability that we may not even have, and that is something that they are not able to determine right now. And so maybe, you know, this bill needs to wait. And I think it's the opposite of putting more pressure on them to determine facts or liability when they have not even received from the aggrieved party all the facts. They said there's nothing in their office that has been received regarding this case. They don't even have the NOV. So even so many aspects of this potential liability are not before the Attorney General. I mean, we can try to send our files over to them, but I don't think that's how they should be determining liability. I would think they're either going to need to get a claim from somebody, the aggrieved party, the Chamorro Land Trust, you know, or someone asking them to. The Chamorro Land Trust, who is the client, has not asked the Attorney General to find a way to pay more money. They came to the legislature because they knew it exceeded their authority to pay any more money. That's why they came to us, because they knew it exceeded their authority, and they knew there's no way it was not approved by their commission, and it's beyond the scope of what they are authorized by law to do. Anyway, so I object to that motion. In fact, I think it's insulting to the Attorney General's office, who represents all of us. In this particular instance, they do not have the materials that they would need, I would think, just because of what they've said earlier about what's not before them. Thank you.
Senator Esteves, you may close.
Thank you, Mr. Chairman. You know, a lot's been said regarding the motion, and I understand that, you know, there might not be decision or information on the matter, but I think what's very clear is the Attorney General won't work on an issue unless they're compelled to do so, either by triggering a small claims or maybe by action of this body. Otherwise, they'll just, you know, kind of sit around. There'll be no initiative on this matter. And I think kind of a lot of the back and forth and discussion going on in this body in terms of deliberation has been on some very key information. I think that maybe a determination from the Attorney General that would have been readily available would have helped us render our decision or make any adjustments necessary. But now we're hearing, well, you know, we were just waiting for somebody to tell us to work. And that's kind of the situation we're in. With regard to the claim, you know, without speaking on the matter too much, and specifically of why I think the motion is important, is that the information derived, although it might not be of use to the body today, although it might affect and not support the passage of this measure or the failure of this measure, or maybe not provide us enough information to move forward with the measure, would still trigger the Attorney General's office to put the work in necessary so that future bodies could deliberate on this, and future agency heads have additional information. Because as long as we keep saying we can't do anything because there are so many holes, but we allow for these holes and mysteries of information and gaps to remain without finality to the situation, we're not doing any justice into the future. I don't necessarily support this measure. You know, I might seem like but I'm just hearing many different things, right? There's so many claims on each side, right? Is it a contract? Is it not a contract? Is it valid? Is it not valid? And I understand the situation that the contract or agreement is still in place. Is a party even able to? Maybe the Attorney General can ask that question. Is a aggrieved party able to file suit against the government if the contract is not yet complete? Or does the contract have to be completed? Then within that time frame, they can file the claims, because it's a long period of time and a lot of things happen. And as a businessman, I understand the situation. If a business is strapped, trying to pay all their obligations, and the government is refusing to pay anything, and they have to wait till the term of the contract to file for cause, then that could put them under. That means lost jobs. So I think it's important to discuss these matters with the body. It's important to turn the I don't knows into more conclusive answers. And if it takes this body to instruct the Attorney General's office to put the work necessary in so that we can do our jobs, I think that's important. I think that's vital. And I understand that, yes, the opinion is that it's a separation of powers. But, Mr. Chairman, I just want to let you know that I've considered an amendment within Committee of the Whole to maybe just give the CLTC authorization. I don't think that's a separation of powers issue. If we say the CLTC has authorization, no specifics, to amend the lease agreement. And those are amendments that could potentially be proffered within Committee of the Whole and by this body that would correct the deficiency on the current legislation before we pass. But however, if we're not getting enough input and we're not having a good, I guess, working relationship, and there are too many I don't knows from parties that should be providing this information to better assist us, and work collaboratively, then I don't think we're going to be able to come to any type of conclusive decision, and we're not going to be able to deliberate appropriately. And so I think it's essential that if there is a single individual who has more knowledge into this, who could answer questions better than I don't know, I don't have the answer, I didn't do the work, then I think we should have them before us and make the determination. The bill may be inorganic now, but that doesn't mean it's going to be inorganic once we do amendments to make the corrections. And it's important that we come together to try to make legislation as the best, leave here and vote it on the best possible product we can have, and then see where the consensus is at. I think people all have different opinions on the matter as to whether or not this is justified, whether or not we've aggrieved this party. I think there are so many different opinions and thoughts on the matter. Some are just tied to whether or not this is organic or not. But those are all things we can work out or maybe not work out within this body, and we can only do that if we have the most information available to us. And so that's why I'm proffering this amendment forward, to see if we can get somebody from the Attorney General's office who potentially, and most likely the person who works with the CLTC, who should be able to provide more information as their representative.
On the motion, there's been an objection. All those in favor of the Esteves motion, please indicate by raising your hands. Motion fails. At this time, the chair will advise the Attorney General's office to not comment at all with respect to the license agreement. If there's questions with respect to process, that's fine, but avoid any discussion with respect to the license agreement, as the members of the body, that we don't want any kind of dichotomy here where some members' questions are not being answered while other members' questions are with respect to the license agreement.
Mr.
So,
Chair,
just a point of order, Mr. Chair.
Senator Nelson, you're recognized.
Thank you. The previous speaker said that because it is inorganic and unconstitutional, we should work to make the bill, we should work to address those matters on the bill if it is sound legislation. And so I believe that if we limit what the Attorney General's office can and cannot say, we will not be able to reach that goal of making the legislation constitutional and organic to the laws of Guam, as another previous speaker mentioned, we took an oath to protect.
Senator Nelson, the AG's office may comment with respect to Bill 350,
Mr.
but
Chair.
we're avoiding comment with respect to the license agreement because some questions are being answered with respect to the license agreement and others are
Mr.
not
Chair,
being answered. And so
I understand, but Bill
we will
350
entertain any
does
questions and then we'll
involve
just
the
provide
license
guidance.
agreement. Bill 350 makes changes to the license agreement.
Right. That's
So I
correct.
think it's very germane. Thank you, Mr.
Mr. Chair, I object to your censoring the answers of the panel. I mean, this is the first committee of the whole I've been in where they're not allowed to answer questions until you have edited the questions or their answers. And I would just ask, let's just proceed with as transparent as possible. We ask questions, they answer. If they feel they can't, they will tell us that. I don't believe they're incapable of doing that. They will tell us what the parameters are. And I object to you saying what they can or cannot answer.
Part of the problem, Madam Speaker, is that in our rules of engagement, we've also established that the panel members shall answer the questions to the satisfaction of the members. If you recall, Senator Rodriguez, in his opening after when we initiated round 2, expressed, he voiced like some extreme frustration with respect to how there was an inability to get certain answers with respect to the license agreement. At this juncture, we have certain members who are seeking answers and they're not getting it. And then we have other members who want to ask more questions with respect to the same subject matter that there may be some answers to. And so in the interest of fairness, I'm trying to make sure that all members are either able to get all their questions answered with respect to the subject matter, or we're not going to be discussing the subject matter because the parties who are supposed to answer are not fully prepared to answer with respect to that subject matter.
Now you're
And so-
interpreting, Mr. Chairman, and I've just never seen this kind
You're
of behavior.
continuing your
here.
point of order, Madam
Yes,
Speaker?
this is a point of order. I am objecting to you editing what the panel can answer and editing what we can ask. The whole point of this is to get information. You're going to ask us to vote on a bill, and then you're going to restrict us from getting the information. I just say let it flow freely. I mean, why such efforts to censor what they can or cannot say?
First of all, Madam Speaker, there's no censorship.
And I think you need to, maybe you need a motion
there's
in
no
order
censorship,
to
Madam
start
Speaker.
limiting the testimony.
There's no censorship in this committee of the whole. There were previous questions asked by prior members, and they were told that they're not going to be afforded the answers because the questions were not.
So let that be repeated on the record over and over. It's
Madam
fine.
Speaker, you need to respect the chair. And so these members were not able to get their questions answered. We can address this one of two ways. We can recess until those answers are available and provided, because the chair wants to make sure that the committee of the whole is being consistent. You're either going to ask questions and get answers. Senator Rodriguez has a lot of questions that were not answered, or we're going to not discuss the subject matter because the parties that are responsible for providing the answers aren't able to answer all the questions that are being proffered. And so that's the decision of the chair. If there's a motion to overrule the decision of the chair and to allow questions to be proffered and so for some to go unanswered, you may make that motion.
Well, I don't recall a motion being made to limit the scope of our questions.
Now, that's the ruling of the chair, Madam Speaker, that we're going to either have all the questions answered or not going to address the subject matter.
But there's no such ruling without a motion. There's been no motion to limit the questions or the answers.
That is the ruling of the chair with respect to the rules of engagement that we adopted in the beginning of these proceedings. So, would you like to overrule the ruling
rules
of the chair?
of engagement, if I read, this is really unnecessary. What you're doing is limiting the testimony, and the rules of engagement where we were going to have 3 rounds of questions.
Madam Speaker, what we did when we established the rules of engagement was the members of the panel shall answer the questions to the satisfaction of the members. Now, Senator Rodriguez, in the beginning of round 2, made it very clear that he's dissatisfied of the answers. The chair allowed for the proceedings to continue because the Attorney General's office the chair was under the impression that the Attorney General's office was not able to answer questions with respect to the license agreement. Now we have conversations that are being made that they're saying they can answer some questions. And if we're going to answer some questions with respect to the license agreement, then all members should be afforded the opportunity to have their questions answered as well. Those are the ground rules that we established, and I'm just holding firm to that. If you wish to overturn the chair on the ground rules that we established, you may make that motion.
No, I'm objecting to you making a new rule right now.
So if I may, we are in a committee
Senator
of the whole. Mr. Chairman, I'd ask you, without making a formal motion to overrule that, maybe you reconsider your judgment on allowing them. I think it's been established very clearly that the Attorney General's office, at least the representative here before Committee of the Whole, came unprepared and would not put any work without being compelled by this body. And it's already been kind of established that this body does not want to compel them to put in the work to verify or review or do a proper review of the license agreement. So I think that's been established very clearly on the public record. And I think in the spirit of compromise and being collegial, if you would please consider altering your ruling, allow whatever questions to be asked, and so we can move on.
I'm totally fine with that, Senator Esteves. The ground rules that we established was that the panel members shall answer questions to the member's satisfaction. That did not occur with Senator Rodriguez's line of questioning. The chair moved forward because the chair interpreted that the individuals present were not capable of speaking to the license agreement. That we have new information that says otherwise, and we've had a whole dialogue now about whether or not we're going to get the answers. We've adopted this at the onset. I just want to be consistent to my fellow members, and so if there's a motion that we strike the requirement that questions shall be answered to the member's satisfaction, I'll entertain that, and then we can strike that.
Mr. Chairman, I'd like to make that motion only because I think, like with any committee in the whole, and while I understand your position and what you're trying to do and facilitate this this committee, I think any member before here, sworn before this body, can only answer to their best of the ability, and whether or not that's to the satisfaction of the member is very, I think, subjective, member to member. But I don't think it's not in the spirit of trying to move forward and get information for everyone. So if that's the thing that's precluding us from moving forward and members being able to ask their questions, I'd like to make that motion that we strike that provision of the rule in Committee of the Whole.
Sure. Without objections, so ordered. Speaker Terlahi, you have the floor.
What are we on right now, Mr. Chair?
You had initiated a question to the Attorney General with respect to the license agreement, and the chair halted that discussion, and we moved to a motion to further elaborate whether or not we were going to have additional representation from the Attorney General's office for more answers, given Senator Rodriguez's unanswered questions. We have now amended the proceedings to make it unnecessary for us to fully vet his unanswered questions, and you continue to have the floor.
Thank you. I guess I wanted to ask if the Attorney General's office thought that the legislature should account for should remedy or should the legislature consider paying a company for something that is beyond the scope of the Chamorro Land Trust license agreement? Should we consider the verbal statements back and forth between the parties? Should we consider that the Chamorro Land Trust themselves say that they are only liable for 1.6, but should we consider more than that at this point, based on this one license agreement?
Yeah, I really wouldn't want to comment on that. I think the legislature is free to do whatever they want, generally.
Thank you. I'm not sure, Mr. Chair, could I come back because I lost my train of questions during that whole motions.
Madam Speaker, the chair will indulge. Any other members have any, Senator Rodriguez, you'll be afforded to close on round 2. Any other members have any questions for this panel on this second round? Senator Esteves, you are recognized.
I know this might be kind of a long shot, but to the Attorney General. Again, it's a long shot. I know asking an attorney, there's never a quick answer, right? I respect that. I do respect what you have to do. Let me be clear. We all have jobs to do. If there was an amendment to the bill itself that just gave authorization for the Chamorro Land Trust to make whatever necessary amendments they feel that they need to make in conjunction with consistent with all the other statutes, inclusive of the board, the director, the administrator. Would you view that as an inorganic provision?
Yeah, I'm sorry, Senator. We couldn't really answer that. Everything takes, law itself is a slow, deliberative process. That's why it takes, a long time to get a case to the court.
Of course.
And it's just something that we just can't do off the top of our heads. I'm sorry.
No, I understand. Thank you. I guess that answers my question. And again, it's very difficult to do this, Mr. Chairman, in this kind of setting, especially with a lot of kind of big things being thrown around, right? I mean, obviously we potentially owe money, things are inorganic, and so this is a very difficult piece of legislation to work to, and I wish we had more time, because I think that's valid. If there's a way to make this better, more palatable, with respecting the separation of powers, allowing the powers that be that make the determination and work out the details, that would be preferential, but sorry, I mean, I'm just going off the cuff. It's difficult. It's a difficult situation. Thank you for answering that.
Senator Steves, this will exhaust your line of question for round 2.
A point of information, Mr. Chair.
Senator Nelson.
It's not only inorganic, it is also unconstitutional. Just a point of information.
Senator Espadon, you have the floor.
Thank you, Mr. Chair. And I'm going to just try to ask the question that the previous senator was trying to bring to light. And I think perhaps a more direct question might be in line with the concern that the Attorney General's office has with this bill. And that is with I believe it's on Section 3. I'm sorry, I believe it's on Section 2 now, wherein the bill basically says authorization and recommendation for an amendment to existing CLTC license agreement. Whereas before, in the original version of this bill, it was mandated. Now the words have changed to recommended. And even with that, the Attorney General's office has opined that really, based upon case law, they still object to basically having the terms of any kind of terms for the licensing agreement to be in this legislation. I think the real question that the previous speaker was trying to ask is if we eliminate eliminate this section, Section 2, which basically authorizes and recommends an amendment, and then with the words that follow, if there is an elimination of that section, would their objection relative to a separation of powers still be there?
Senator, I think that's just something that we'd have to have some time to look into. It obviously, addresses the main concern that,
right.
My co-deputy mentioned earlier today. So we'd have to take some time to look into that.
Okay, but it seems reasonable, because it seems to be that the Attorney General's position is that it was this section that really causes a little bit of causes concern in terms of dictating the terms of a contract, even if it's just recommended.
That's correct.
Right. But if that is not even part of this legislation, then I would imagine that concern goes away, because it's no longer in this legislation.
Right. It's certainly not as obvious, put it that way.
Okay, good enough. And then, again, then I'll ask Mr. Borja. Mr. Borja, is it even necessary to have this verbiage in here? You heard the previous speaker say that he's contemplating an amendment in which it just gives you authorization to renegotiate, or at least to make an amendment, right? Is this verbiage that's included in this bill necessary?
Usually in the legislation I've had to deal with, we only seek an authorization to be able to do something which establishes probably certain points that should be accomplished within that authorization. But it's actually in Section 3 that all we're seeking for is the compensation section to pay off the balance of what we believe is due.
Right. And in Section 3, hang on, let me turn to Section 3.
Page 7.
Right, that's something that's been added recently, it seems. Continuing appropriations. But even then, this is one of those areas where, and the arguments have been made before, and I'll just restate it, that we cannot bind future legislatures. So even if we do say there's a continuing appropriation, come next legislature and they say, you know, we need that money for something else, this is out the window, right? But I wouldn't imagine that this appropriation would be included in the licensing agreement, or that you would amend, because the money is not coming from the Chamorro Land Trust, it's actually coming from the revolving recycling fund, right, that's under the jurisdiction of Guam Environmental Protection Agency. So you couldn't include this in any agreement in terms of an amendment to your licensing agreement with COCU.
Well, again, that I would have to defer that specific kind of language to our counsel. But again, it was the things that we were seeking for to try and find a resolution to this whole matter was to get authorization and appropriation to pay the balance, which the Chamorro Land Trust doesn't have the authority to do, and we obviously didn't even have the money to do it, so it had to come from somewhere else.
Mr. Arecki, this whole business of removing solid waste, and I think there were a couple of names mentioned. FEMA was mentioned, some other company, I believe, DRC?
DRC.
Was mentioned. FEMA was mentioned. Was there any reimbursement by FEMA to be able to do this project, or was there some kind of monies to be able to move this project along?
I have to admit, I'm not that expert on that, but there was some reimbursement. I know DRC was paid. DRC was involved in that, and that, I think, is an issue that kind of rankles my client, because the big off-island companies were paid for the solid waste removal that they undertook, but the COCU wasn't.
And they were paid
there was some reimbursement.
But were they paid with federal monies or local monies? I mean,
I'm really not sure on those specifics.
I mean, because again, if they were paid with federal monies, then that's one thing. If it was paid for, if their services are paid for by local monies, and they were paid and our local company wasn't, then I think that's definitely a different issue. But you know, if the pot of money was different of what was paid to that company, and now we're seeking from the local government, then you know, there may be something there. I just curious. You know, there was mention earlier also about, you know, I believe several years back, maybe even a decade ago, there was a big fire up at the location in Barrigada. Was that the location of where COCU was operating out of?
I believe it was. Again, I don't know all of the specifics. I know some. I believe it was caused not by COCU per se, but by some other contractors that were working on the property. I can say, though, over the years, COCU has undertaken a number of efforts to remediate the property. Okay. One of which was paying out of COCU's own pocket for a $100,000 study that was done by a local environmental company to propose how to clean up the property. And then also at another point, actually a contractor was hired that cleared the property. So there have been some efforts over the years to remediate. But it's true, the job's not fully complete.
But well, then the question becomes, is the remediation because of the conditions that was created by COCU, or by conditions that were there previous to COCU?
I'm not precisely sure. I believe it was a combination of the two. There was a fire on the property where the tires that were already there somehow
Then I'll ask
got on
EPA.
fire.
Are you familiar with that?
So the NFO states that the tires had exceeded what they had initially were initially permitted for, and so that was part of the NOV. And to assume who started the fire, that's the fire department inspector. That's not my call. But the result of the fire may and most likely cause contamination in that site. So that needs to be addressed. There was reference of a study done, but it was concluded that that study was not sufficient enough, and so additional studies need to be performed.
And do you think they'll ever be performed? I mean, considering that that was years ago.
Right. I would like to think, not like to think so. I mean, for the situation at hand, it needs to be done.
Right.
I've been in this position for 2 years and 2 months. I have to take fault, not my team, me, has to take fault for not addressing this. I've had other issues that I tried to address in the 2 years and 2 months, but this definitely needs to be addressed at some point. And whether it's COCO or some other entity that needs to help us address it, it should be addressed.
Okay, and the only reason why I bring this up, Mrs. Chair, is because, and I guess it seems obvious, we can't hold anybody responsible at this point, but there were public expenditures on that whole lot, a lot of public expenditures. And so the question in my mind is if there's some kind of offset for what occurred on that location that was under license to this company, right? And yet the government had to expend funds for something that happened to the detriment of the public. And so I guess my line of questioning at this point was to see is there was going to be any kind of offset for the cost to the government to assist COCO in putting out the fire and remediate the property that they are in control of. That's just the point I wanted to make, but I'll allow for another round of questioning to go forward. Thank you, Mr. Chairman.
Senator Espadon, just an advisory. We've only authorized 2 rounds unless there's a motion to extend questions. So this may be the final round. Did you have any further questions?
Well, then, may I reserve the right to come back in and allow somebody else while I formulate one more question in my mind?
The chair has indulged Acting Speaker Terlahi and Senator Espadon.
Thank you, Mr.
Next
Chairman.
on the list, we have Senator Torres. You're recognized.
Mr. Haraki, what is the term of the license agreement?
A microphone, please. Thank you.
Does it end? Is it continue?
It's a, let's see, 2003, 20-year term.
Okay.
So still the issue, though, was, what you had mentioned before, was raised by the CLT chairman. When does it start? When does it end? Actually, the agreement was not acknowledged till 2003. So we've always felt that an earlier provision says that it begins 2 years after the execution of the contract. We think the acknowledgement was a critical part. That's why we say that the contract would run from 2005 through 2025. But if the other interpretation is correct, it would be 2003 through 2023.
So it would be nearly impossible to cure the liability, say there was a liability, for argument's sake, of $7.5 million. It would be impossible to cure the liability within the term of the license agreement, relying solely on an offset against rents. Is that correct?
Well, as I indicated, COCO did make, I think, fairly substantial efforts. I mean, the $100,000 it paid, and I'm not quite sure why that agreement wasn't acceptable to EPA. But then even after that, we have been negotiating, and there, as I said, I think about, I'm going to say within the last 2 to 3 years, there was a clearing of the property and a cleanup of some of the property. So my point is there have been efforts. That's possible, but again, the problem is all that money, of course, comes out of COCU's pocket. And if it's going to cost $300,000 or $400,000, I think you can see that was our estimate, by the way. Right. That's what's placed in the bill to be allocated for the cleanup. But it would probably cost something in that area. But time-wise, assuming the cleanup plan could be agreed upon, arrived at, I think it's conceivable within that time period. It could be, yes.
Okay. Thank you. No further questions. Thank you, Mr. Chair.
Thank you, Senator Torres. Any of the members that have not had any questions during this round? If not, the chair will return back to Acting Speaker Terlahi for her opportunity.
Mr. Leon Guerrero, the bill the bill proposes that we recommend to the Chamorro Land Trust Commission to adopt this new license agreement or this amendment to the license agreement that would authorize the following business activities on that lot in Barrigada. They would include the solid waste processing facility, the solid waste management, disposal, and recycling, hard fill, storage and warehousing, operation of construction office, and storage and sales of construction and building materials and equipment, and laydown yard. Are these consistent with its current use?
So those are a lot of activities and operations that you had mentioned on the bill. For me to openly say that these are things, okay, let me just answer the question. Those were some of the activities that were done on that site prior to the fire happening, correct?
All right, were those activities authorized? For example, the hard fill?
I don't recall the hard fill, but I would need to check on that at this time.
Are these activities currently authorized?
None of those at this point are permitted as far as I know. The former permits, again, they have a notice of violation on them, and so non-compliance would still leave it that it could be argued they may, excuse me, could be argued that it may be open, but with a notice of violation and non-compliance, my personal opinion would be it's not allowable at this time.
Thank you. Has the Chamorro Land Trust received any advice that they are liable for $7.5 million, legal advice?
Not that I recall.
It's my understanding from the chairwoman's testimony that the Chamorro Land Trust opposes most of the provisions here, particularly the land exchange as part of compensation, or allowing use of another lot as part of the new agreement. And allowing these activities to continue on this lot. And think instead she wants this lot to be cleaned up.
Well, those were not any of the original intentions for the original license agreement. And so it seems as if that amended agreement was adding a lot more to the functionality that wasn't originally intended, nor really discussed with the Chamorro Land Trust Board of Commissioners. And again, it goes back to the point of what was the start date. Our contention in that testimony was that it was in 2003, so if 20 years later, that would be 2023, it's only really 4 years away. and it's time to start winding down some kind of operation rather than expanding it beyond what it was originally intended for. Because I don't think that amended agreement adds any more time either. It's just, you know, our intent of it, what the request was just to find a way to compensate the cocoa recycling outside of what the CLTC could compensate.
Thank you. To the AG's office, this, so the bill is proposing that we recommend to the Chamorro Land Trust that they adopt this amended license, or we authorize them to adopt this amended license. This license would now very specifically say that the amount, the dollar amount that that is due to cocoa recycling, as opposed to the current license, which does not say that. And would this, I mean, we're talking a lot about liability, whether it exists or not. Would the CLTC's adoption of this amended license agreement incur a liability for the CLTC beyond the 1.6 that they might be liable for right now?
Just looking at it, I think that would be a fair interpretation.
Mr. Borja, if the money does not come out of the recycling revolving fund, does the Chamorro Land Trust have $7.5 million to take care of this new obligation that it would be incurring?
No.
Thank you. No further questions.
Thank you, Acting Speaker. We circle back now to Senator Espadon. Any follow-up questions for this this final round?
Mr. Chairman, if I could just, I don't know if it's a point of information or point of order. I think it was just...
Point of order, Mr. Chair. Is it a point of information or a point of order?
Point of information, actually, or actually a motion. I think I'd like to strike that or contest that statement made because it was previously stated by representatives from the Attorney Generals that they don't make statements without review. But what we had just heard is like, and I quote, well, just based on just looking at it right now, I think that's a good assessment.
Point
or
of
concurring.
order, Mr. Chair.
I think that's just contradictory to what they had just said.
Point of order, Mr.
Yes.
Chair. The Attorney General's office is here part of a panel. They are not on trial.
The chair will recognize that we have altered the rules of engagement for panel members. The door has now been open for certain answers to be proffered, or certain questions to be proffered, and answers to be rendered that may not be consistent with other members' questions and their desire for such answers. But the committee will take notice of your protest, Senator Esteves. Senator Espadon, you're recognized. But before we do that, if the body and the panel will just indulge, I have a message that we may need to recess for a brief time to reset our technologies for broadcasting. So the Committee of the Whole will stand in recess for 10 minutes, and we will reconvene at 5:15.